marriage of Geneva Zilka and Vincent Zilka. Appearances are we do have Mrs. Zilka appearing in person with Allison Moore. We have Mr. Zilka appearing in person with Rose Allen. We have guardian ad litem Renee Landgraf appearing as well. All parties appear in person. We're set today in this matter for the second half of this contested divorce hearing. When we left off, I believe we are now at the point for cross-examination of Mr. Zilka by Ms. Moore. Is that correct?
That's my recollection, yes.
All right, I'm going to have both parties again. Please stand, raise your right hands and be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may be seated. Mr. Zilka, please come up here and have a seat at the witness stand.
First, you're not an active duty member of the U.S. Armed Forces or its allies, correct?
No.
Okay. And is it your intention to waive maintenance from Ms. Zilka?
I'm unsure. As far as I know, yeah.
Are you asking that Ms. Zilka pay you any monthly payments as maintenance
No.
after the conclusion of this divorce?
No.
And you understand that if the court were to grant that, that would be a permanent and final waiver on your part?
Yes.
Mr. Zilka, can I ask you to please take the microphone and move it closer to you? Thank you.
Are you at all apprehensive about that, or are you sure that you want to waive maintenance today?
Yes.
Do you need any time?
What is the answer? Which question is that answer to? Because it was a compound question.
Sure. I'll rephrase, Your Honor. Do you need time to consult with your attorney before proceeding today?
It probably wouldn't be a bad idea.
It would not be a bad idea.
Yes. It
So
would
you
be a good
need
idea.
You need to consult with your attorney as to whether or not you wish to waive maintenance.
I don't think I need maintenance, so
All right.
it's just, this is the first time it's been brought up, so I hadn't talked to her at all about it, so.
All right. So at this time, you're going to answer questions, but after you've had a little bit of time after you're off the witness stand to consult with your attorney, you may or may not change your mind.
Yes.
That is fine. You may continue, Ms. Moore.
Thank you. Are you in relatively good health today?
Relatively.
And you're able to support yourself financially without contribution from Ms. Zilka? Is that correct?
Yes.
Okay. And to this point, as the case has been pending, Ms. Zilka has not paid you any monthly maintenance, correct?
No.
And in fact, the money that has been used has been your disability and some wages that have supported the family, correct?
Yes.
And that's been deposited, at least in part, into a joint account that's paid all of the expenses, correct?
Yes.
And so since the pendency of this case, you've not received any monthly contributions from Ms. Zilka.
No.
I want to ask a few questions about your workers' compensation award. Now, that was from a back injury that you suffered while you were working in Arizona, is that right?
That is correct.
And initially, that claim for workers' compensation was denied, correct?
It's complicated. Initially, it was approved by the insurance company, but then when they contacted, or they finally managed to get in contact with the company that I used to work for, then they changed their mind and denied it.
And then presumably after that, you needed to retain an attorney and proceed to get your award?
Yes.
And my understanding is part of that denial was they referenced a pre-existing condition, is that right?
That is correct.
And that was related to a back injury that you suffered from your service?
Yes.
And that tied into your VA disability rating, correct?
That is correct.
And you have a 100% disability rating through the VA, correct?
That is correct.
And so medical expenses that are considered relevant to a service injury, the VA pays those expenses in full, correct?
As far as I know.
Now, you testified that you also needed to put $140,000 of your workers' compensation award into a medical set-aside account, right?
That is correct.
And in reality, you didn't personally receive $140,000 from the workers' compensation award, correct?
I received whatever the amount was. I think it's 120 some odd thousand.
So you received less than $140,000.
Yes.
And some of those funds you advanced as a down payment for your current residence, correct?
That is correct.
The 75,000?
That is correct.
In the vein of Arizona, you had retained an attorney to pursue claims against your original realtor for that Arizona property, correct?
That is correct.
And presumably if you retain an attorney, you need to pay them a retainer or an advance fee. Is that correct?
That is correct.
How much was that for that attorney?
I don't know off the top of my head,
More than $1,000?
approximately.
More than $5,000?
No.
So somewhere between $1,000 and $5,000.
Yes,
And that attorney did some work for you, but ultimately that issue is resolved, correct?
currently.
Are you currently in any litigation related to your first realtor for the Arizona property?
No,
Are you anticipating any litigation towards that realtor?
no,
Do you have this retainer still on file with the attorney?
I'm not sure how much, if any, is left of the retainer.
Are they still working on your behalf?
No,
Have you received a refund?
no,
Have you received a final bill?
no.
What funds did you use to make that retainer payment?
Don't remember the exact time frame of everything, so it would have been my funds that were separated
Where do you have your funds separated?
into a personal account.
What money goes into your personal account?
This money I get from work,
So your wages go into this personal account,
yes,
and those would have been the funds that you used to pay the retainer?
yes.
The Arizona property, how long did you reside there?
I was there from the end of 2020 until January of this year.
And so presumably if you're there for those many years, you had the place fully furnished
For the most part,
and you had enough regular household appliances to make food for yourself, for example?
no. I had 600 square feet of space and it wasn't enough to furnish a full actual house or anything else. And the dishes and stuff that were down there, the pots and pans, were all damaged and need to be replaced.
How were they damaged?
The interior coating of them was coming off.
And so when you left Arizona, you threw them away?
Yes,
And did you have couches, beds, any other items of personal property at the Arizona house?
I had my queen size bed that was in my room and a couch that was falling apart that was in the main living area, and a bed that I built for the kids using some blue mats that we had found that I brought back with me.
And that was all that you had furnishing your Arizona property?
There was a bench that some cooktops sat on, but that got left there. And then there was a small folding dinner table that was in poor shape that I ended up giving away because I didn't have enough room to fit it in the truck.
Did you sell anything from the house when you moved back?
I think I got about $100 for some of the food and other things.
Going back briefly on your military service and your VA disability, you mentioned at the last hearing about your rating. Included in that is also depression, correct?
Yes,
Let's talk a little bit about your employment. So you've been working at Northwoods Technical College since July of this year, is that right?
that is correct.
And I believe your testimony at the last hearing was that's a Monday through Friday position.
That is correct.
Prior to that, were you unemployed?
That is correct.
How long were you unemployed prior to starting at Northwoods?
That would have been from January until July.
of this year?
Yep.
And then prior to your unemployment, where were you working?
I worked at a precious metals refining company called Advanced United Refining.
And what did you do there?
I was an operations and maintenance manager.
And does it sound correct that that would have been from approximately July 2023 until you left and returned here in January 2024?
That is correct.
And then prior to that, you had a period of unemployment as you were dealing with back surgery. Is that right?
That is correct.
Do you recall approximately how long you were unemployed related to that?
It would have been over a year. I think I was let go in January of 2020.
Of 2020?
No, I'm trying to think of the exact year. I don't recall off the top of my head, but it was for a while. I was actually let go in December, but then they paid me until January. I think that was of 2022, 2023.
Prior to that, you had been working at Atlas Motor Vehicles in Arizona. Does that sound correct?
Yes,
And I believe from your discovery responses, you believed you were working there from February 2021 through March 2022. Does that sound right?
no, it would have been 2020, I believe.
So what dates do you believe you were working there?
It would have been February 2020 to 2020. 2022, I think.
So about 2 years there?
It would have been 3 years, 2023. Or yeah, it would have been 2 years because then because of them not letting me go, I would have been on the not paid, but still like part of the company until the end of my 3-year mark, and I was eligible for all the vestment of my stock options.
So you think it was the 3 years then?
Yes, it was just over 3 years, but I wasn't paid for all of that.
And as I reviewed your financial records, your ending salary was $75,000 a year there. Is that correct?
That is correct.
Is it accurate to say that from 2020 through 2024, you've been looking for jobs in various places outside the state of Wisconsin?
I've been looking for employment wherever I can get it.
And there was a period in 2022 where you had an interview in Florida, correct?
Yes.
That was a
Well,
job interview down there.
I didn't go to it, but it was for a job in Florida.
You applied for it.
Yes.
And then in 2023, you had an interview for employment in West Virginia. Is that right?
That is correct.
In June 2023, you were looking at getting a passport for a potential job in Dubai. Is that right?
Yes.
And then in August 2023, you were interviewing for a job in Alaska, correct?
That is correct.
In addition to these various employments, have you also run for any political offices?
I have
Which types of political offices have you run for?
Wisconsin State Assembly and then Grantsburg Village President.
Do you recall approximately when you ran for assembly?
That would have been in 2017, I believe.
Presumably that took some campaigning on your part.
Yes.
Do you recall approximately when you ran for village president?
It would have been just after that time frame, 2017, 2018.
And same thing there. I mean, I imagine that would include some campaign hours on your behalf.
Minimal. I was much more busy with the family and stuff at that point.
Did you also obtain your helicopter's license, or are you still working on that?
I was asked to stop it
By whom?
by Geneva.
When?
when I was campaigning for state assembly.
So back in 2017 approximately?
Yes,
Have you gone back or done any other classes since then?
no.
How were you paying for pursuing that license?
It was VA, I think it was chapter 33, my GI Bill.
And were those going to continue or were those benefits stopping?
They would have stopped at some point.
In reviewing some of your exhibits, you submitted, just for the court's information, it's Exhibit 106. And that document included some of your credit card statements. Were you familiar with those statements?
Yep,
One of them I see here is a Freedom card. Is that card in your name alone?
I'm not sure whose names are on it. I know that Geneva has access to it.
She's certainly a signatory on it,
Yep,
but the bill, if it's coming in just your name, probably is just your name on the debt.
I don't recall off the top of my head.
And same thing then, if you recall, for Wells Fargo, that bill is coming in just your name. Do you know if Geneva's name is on it or if she's a signatory?
I believe she's a signatory, but I don't believe that it's her account. I think that's just mine.
And following the conclusion of this divorce, are you willing and able to remove Geneva's name from these debts?
Yes,
When were you employed at McNally's?
that would have been from 2014 to 2017.
Did you receive any stock ownership or equivalent through that employment?
I did.
And where were those funds deposited?
That was into my, I think it was then Scott Trade account, which has since been transferred over a couple times, and now it's the Charles Schwab account. Or the one of the Charles Schwab's accounts.
Regarding the debt that your parents indicate you owe them, you would agree that that was all incurred prior to your marriage to Geneva, correct?
Yes,
And in reviewing that statement, it appears it was for a vet bill and living expenses. Does that sound right?
yes,
You've not added to that debt during the marriage, have you?
no,
Have you made any payments on it during the marriage?
no.
When you were asked some questions by your attorney at the last hearing, you mentioned that you want to use the voice call feature for Our Family Wizard, correct?
That is correct.
And that was for emergencies based on your testimony, is that right?
That's my understanding, or something where I need, or we need more prompt contact than 24 hours.
What emergencies have there been that would have necessitated you using this feature since you've started using Our Family Wizard?
One of the ones that I wished that I had it for was reaching out to her about Evander's braces when she had left him one of the first times without them.
And that was an emergency that would have needed this feature?
I felt like it would have been nice to get addressed relatively quickly, because I was under the understanding that he had needed to wear them at night.
So I can understand you're talking about braces, so I'm gonna guess Invisalign.
No, it's for his legs because he was a toe walker.
Brace, that's right, the
Leg
ankle
braces.
bracelet. When you said braces, I just thought teeth braces and had to wear it because my kid has teeth braces that he has to wear at night. So, okay, I forgot about the toe walker.
Thank you for
Those
clarifying.
braces.
Did you call Geneva
No, I'm not supposed to reach out to her on her personal phone.
except in emergencies?
I'm not supposed to reach out to her on our personal phone. Our only contact is supposed to be through Our Family Wizard.
So it's your position that if there's an emergency, you can't even call Geneva?
It is my understanding that all of our contact is supposed to be through our family wizard, and the call feature is supposed to be set up so that way, if we need to reach out, we can do that through there. So it's recorded. There's no discrepancy of what happened. He said, she said.
So the big thing for you is you need to record conversations with Geneva.
I want to be protected from her.
So I can understand better, is there a restraining order or injunction between both of you?
No.
It's just an understanding between both of you and or your counsel?
It,
Attorneys?
it was set up at one of the last temporary order hearings, and that's what it was decided as.
All right, so it's not a formal order of the court, it's just something that the parties have agreed to.
I think so.
All right, thank you.
Now, I want to talk a little bit about your proposal with Chase. You've agreed that he will continue homeschooling, right?
That was my position at the last hearing, yes. And he was supposed to be doing Khan Academy.
Correct. And so the stipulation that we put on the record at the last hearing was that he would continue to be homeschooled using Khan Academy and some yearly testing for him.
And a reading program.
A supplemental, yes.
Yes.
And at the last hearing, then you testified that despite that stipulation, he should still be with you 50% of the time, and that you could accommodate his homeschooling by taking him to work with you on some days, particularly Fridays.
Yes.
And you believe that that's in his best interest?
I think being in an environment like that could help him see more of what opportunities exist. Like interacting with me and my students and some of the other programs, he can see that there's more opportunities and hopefully enable him, like the hope was with homeschooling in general, to pursue his education more than passively like it has been.
So you're going to bring him into your lectures?
Yes.
So at the last hearing, you said that you would have to do lectures at some point, but he could be doing his own schoolwork at that time.
He can be, yes.
In your lecture?
The way I do lectures is it's more of an interactive thing with my students. We talk about the chapter's material. We go over chapter problems. There's no issue with him sitting in the back of the classroom doing his work.
So he would still be in the classroom, presumably doing some other type of coursework, age appropriate.
Yep.
While you're instructing a lecture hall with other students.
I have 2 students.
Okay, so you're lecturing other kids in an interactive manner.
Yes,
And you, again, believe that's in Chase's best interest.
I do. Because I am there to help him should he need it, just like the other students.
You're working at that time, you're correct?
Yep,
You're paid to instruct those students at that time, correct?
yep,
You're not being paid to educate Chase sitting in the back of the room doing his own schoolwork.
nope.
No other questions?
You're done questioning them?
I am.
All right, thank you. Ms. Langra?
I'm not sure if we touched on the other kids' education, but you believe that the Evander and Aiden should be in public school
Yes,
where Vivian goes to school,
yes,
and that's based on lower test scores, and it would be easier for you and Geneva to facilitate the schedule.
yes. I think the other part of that is there's no disagreement about what coursework should be done or not done, since the school dictates it.
You work in Rice Lake, which is approximately, what, an hour from where you live?
Approximately.
You work Monday through Friday?
Yes, I do.
I believe at the last hearing, there was testimony that you do not work during the summer, or you're not going to be working during the summer.
That is correct. I actually get a month-long break here coming up in the middle of December, and then I get a spring break in March, and then I get basically the entire summer off.
I have a question. Do you get paid for those times off?
Yes, I do. I am a contracted employee.
Thank you.
Now, at the last hearing, your attorney asked Geneva if she was aware that your employment was only going to be for 1 year. Is that the case today, that you only plan on working there for 1 year?
I have a contract for 1 year.
So that will be up in July?
Yes.
What are your plans for work after that?
The hope is that the contract will be renewed for another year.
Okay, so it's a contract that can be renewed annually. You're not looking to get a different job at
No.
the end of that time?
No,
Okay.
Just refresh me, how much do you make annually on that contract?
around $62,000 a year for working 1,330 hours per year.
1,130.
1,330.
All right, thank you. I'm sure I have that in my notes, but I just want to have it right now. Thank you.
And Your Honor, just for your reference, it is on Exhibit 101, page 9.
Excellent, thank you. I'm looking at that right now. But I will turn to page 9. Thank you.
Over the course of the last couple of months, has Geneva asked you not to come on her property or the property of the marital home?
Yes,
And have you abided by her wishes?
as much as practically possible, yes.
Has she asked you not to come to the marital home when it's not your placement days, when you're not dropping off the kids or picking them up?
It has been brought up.
Have you stopped by the marital home to talk to the kids or see the kids on her placement days?
When I received permission, or at least what I thought was permission.
Shortly after the last hearing, you got a puppy, is that right?
I did.
And did you tell the kids that you had a 5-day period with the puppy to decide whether or not you could keep it?
I told them that that was something that the adoption agency had in place.
And right around that time, the kids were supposed to have placement with their mother.
Yes,
And are you aware that the kids were asking their mom if they could come over to your house and stay there because of the puppy?
Your Honor, I'm going to object to the line of questioning. We're bringing in potentially hearsay. I don't know if the guardian ad litem is planning to testify about these conversations, but I think it's improper to assume things that aren't in evidence.
Sustained.
Are you agreeable to keep using Our Family Wizard?
yes,
And the kids are involved with the Scouts program.
they are.
We heard testimony from a member of that at the last hearing. Do you recall that?
Yes,
And are you supportive of the kids being involved in those activities?
I'm supportive of them making the choice.
Are you willing to work with their mom to coordinate? They can go to the events and activities that they want to.
I have, and I will.
If you plan on taking Chase with you to work every other week, how is he going to do his CCS appointments and other service appointments that he has during those weeks?
I would make sure the appointments were scheduled in an appropriate time and manner that I could get him to them.
And what happens if on your placement week, the kids have to come home sick from school?
Then I will call and schedule time out of school if necessary. That's the same as any parent does.
And you will be able to be there to get them on the bus or drop them off at school every morning?
Yes,
And you'll be home to get them off of the bus or pick them up from school every day?
yes,
I don't have any other questions, Your Honor.
Ms. Allen?
Very briefly, Your Honor. Now, Vincent, you were asked some questions about your ability to have Chase or Chase's ability to do homeschooling when he's placed with you, correct? Okay. And you were asked about his ability to do some of his schoolwork while you are lecturing. Do you recall that questioning?
I do.
How much of your day when you're working is made up of lecturing?
Maybe a couple hours, a couple times a week.
So what are you doing during those other times when you're at work and you're not lecturing?
I'm working with the students or planning out what's going to be done on following days or building classes for following semesters, reviewing course material, anything that really needs to be done. There's a lot of time where I can make up my own schedule as I go along.
And when you're doing that planning, do you have an office that you work in, or where do you do your work?
I have a cubicle in a student lounge or in a faculty lounge, but I also typically stay in the classrooms that I teach out of.
And are those classrooms large enough for you to be in them and Chase to be in them?
They're large enough for a significant amount of students.
And so while you are doing your planning, your prepping, things of that nature, is Chase able to do his homeschooling work?
Easily, and I'm always accessible to him during those periods.
And during the afternoons, when you're coming home, in the evenings, are you also able to work with him?
Yep.
And as far as the other children, are you, when you get home, are you able to help them with their schoolwork as well?
Yes, I am.
You were asked some questions about the credit cards. You recall that questioning?
I do.
And those credit cards, were those used for the benefit of both you and Geneva?
Yes, everything that is on the credit cards is marital expenses.
And those credit cards were actually used to pay some of Geneva's legal fees, true?
Yes,
And were they also used to pay some of your legal fees?
yes,
You were asked by Attorney Moore about a maintenance claim.
Right.
And you understand that maintenance is additional financial support that one spouse pays the other, either during the pendency of a divorce or after you're divorced?
yes,
Do you think either of you should be paying maintenance to the other?
no,
So you are currently receiving both your military disability and you're working, correct?
yes,
And so when you were asked, do you expect Geneva to pay financial support to you after the divorce is done? Are you expecting her to do that?
no, I'm not expecting her to pay me anything. I think that things should be evenly divided as far as where we're at, and she should pay her expenses and I pay my expenses
Okay.
with her
And-
income.
Okay, and
Yes.
so do you understand that if you tell the judge today, I'm not requesting maintenance from Geneva, do you understand that that means that if she accepts that, you could never come back to court and ask for her to financially support you?
Yes,
You understand that?
yes,
Do you need, now that we've discussed this, because I think you were a little deer in the headlights there when you were being asked those questions, do you need more time to talk with me about that?
no, I don't think so.
Okay, so you don't think so. So,
I don't need any more time. I don't need any support from her. I'm more than capable of supporting myself and the children.
okay. And so you're willing to waive your right to request maintenance today?
Yes,
And do you understand that, you know, one of the factors that the court would potentially look at would be your physical health?
yep,
And you've testified that you have some disabilities, injuries, correct?
I do.
But nonetheless, you are comfortable with the idea of waiving your right to request any sort of maintenance or financial support from Geneva. Is that true?
I am, because I'd have my disability as income should I not be able to work anymore. I should say, in the eventuality that I'm not unable to work anymore.
Because it's your goal to continue to work as long as you can do so?
As long as I'm physically able.
And does your current employment suit your disability as well?
Yes, because it is a very low physically demanding job.
You were asked about whether you're paid for the times that you're not working, so winter break. You recall that questioning?
Yes, I do.
And that winter break pay is part of the total salary contract that you're receiving, correct?
That is correct.
The home in Arizona, when we were here last, it was subject to closing, correct?
Yes,
All right. And did the sale actually close?
it did.
And and Your Honor, this is more just to update the court. So the proceeds from the sale of the home have been placed into my trust account?
They have.
And Your Honor, again, for your information, the amount that has been deposited into my trust account is $97,166.71.
Thank you.
And Vincent, with respect to those funds that are in my trust account, those are still subject to division by the court to equalize the marital estate.
They are.
Now, there was one other significant change since we were here last, and that has to do with the vehicle that you were driving. Is that correct?
That is correct.
You were driving your vehicle was in an accident, is that correct?
That is correct. It was a 2015 Volkswagen Jetta.
Okay, so 2015 Volkswagen Jetta, that was a vehicle that was going to be assigned to you, correct?
It is.
And what happened to that vehicle?
I hit a deer on my way to work and it was totaled.
Okay, so that vehicle's been totaled at this point?
Based off of the quote that I just received this morning, it would cost exponentially more than it is worth.
Was
repair.
the preliminary, what was the preliminary estimate? Do you recall?
I think it was almost $8,000, 79 something.
And so with respect to that, you also just received in the mail a partial insurance refund check. Is that true?
I did.
And the amount of that check, $955.01.
Yes.
Now, also as part of the fact that that vehicle was lost, was there an agreement between you and Ms. Zilka regarding getting a replacement vehicle for you?
There was, we agreed that I could spend up to $10,000 out of the money sitting in your escrow account to be able to find a new vehicle.
And have you in fact found a new vehicle?
I did secure a new vehicle,
And how much did you pay for that vehicle?
$1,500. I withdrew $2,000 from my account because that was the amount that I was understanding to be paid. But then when I went to go pick it up, we agreed to $1,500. So that's what I paid.
Is it a reliable vehicle?
Yes.
Wowza.
It's has a salvage title, so it's not really worth a whole lot, but it's a reliable, good driving vehicle.
Are you good with mechanics?
I
Fix things?
can.
Well, then makes sense.
So pursuant to that understanding or agreement you had with Geneva, did you just get this vehicle relatively recently?
I literally just got it this past week or so. And the idea is it was something that was really accessible that I could access for an affordable amount until I could secure something that is more suitable for a long-term solution.
And during this time frame, when you were without a vehicle, were you using the black van?
I was.
And that van was then returned to Geneva when you got this replacement vehicle?
It was.
Now, when you were in need of the van, I'm going to presume that you had communication with Geneva through Our Family Wizard. Is that correct?
I believe there was communication, but it was because there was a prior agreement made in court that I would be able to use one of the two vans that she has, because I had another incident where the motor, the timing belt on my car had broken and it had caused motor issues. So it wasn't able to drive for a period of time until I had gotten it fixed.
I recall that you had that agreement where you could use one of the vans to transport the children. But where I'm getting at is in your communication with needing to use one of those vehicles. Did you find the communication with Geneva to be relatively good communication?
I still had to go through the lawyers in order to get it.
Okay. Sorry, you may continue.
Vincent, you were also asked about your work comp settlement. Do you recall that questioning?
I do.
And you were asked about whether the VA would be paying for your medical expenses in the future. Do you recall that questioning?
I do.
And what is your understanding of that Medicare set aside?
I'm unable to access certain Medicare and Medicaid benefits until I have spent that amount of funds on my medical expenses before, before I can access those things.
So the Medicare set aside is designed to pay for future medical expenses that you will have or may have?
Yes.
Now, one time I had an extra book for you to review, but I'm reviewing to Exhibit 107 that we submitted at the time of the last hearing, okay?
Right.
And that is what we identified as the breakdown for your workers' compensation.
All right.
And the portion for medical that you received was $140,000. Does that sound correct?
That sounds correct.
Okay, but from that, there were some past medical bills that were paid,
Yes.
some past liens,
Yes.
so that the actual amount you received for the Medicare portion of it is $110,082.74. Does that sound correct?
That sounds correct because they had to reimburse the VA for their expenses still.
Okay, and then there was a second part of the recovery that you received, and it's called the indemnity part. Is that correct? Does that ring a bell for you?
It sounds familiar.
And then that part includes the the permanent disability payment and lost wages or past wages. Is that your understanding?
Yep.
And so from that amount, you received $80,000 for the indemnity portion. Is that true?
If that's what it says, yes.
And from that, the attorney's fees were paid, and that was about $55,000.
It sounds correct.
And there were also costs that your attorney incurred of $254.81.
Yep.
So that the net you received for the indemnity portion is $24,745.19.
It sounds correct.
And from those funds, you deposited those monies into a Charles Schwab account. Is that correct?
No, I think that all got deposited into my USAA account.
Oh, USA.
I tried to put it in the Charles Schwab account that I had set up specifically for it, but they're having problems transferring it into it.
Right, and those are set forth in exhibit number 105?
I believe
Is that your
so.
recollection? Okay.
again, I want to just commend both of you as attorneys for being so prepared and having exhibits for me. Makes my job much easier. For having exhibits for me prior to.
So so Vincent, you did receive, scratch that. So with respect to the USAA accounts, you indicated that that's where you deposited the money.
And I deposited into my savings account, yes.
Now, you also had received a personal injury class action recovery, correct?
That is correct.
All right. And is it accurate to say that that is actually in a Charles Schwab account?
That is correct.
Okay. And Vincent, you were asked a little bit about some personal property. And at the last hearing, there was also a reference to some personal property that you were supposed to be receiving. Have you received all of the personal property that was on that list?
No,
Are you still working to try to obtain that property from Ms. Zilka?
I have been trying to, but she's refused to return any more of it to me.
Are you willing to continue to try to work with Ms. Zilka to obtain your remaining items?
I'm not sure how much more between us we're going to be able to resolve because she has refused to return any more of it to me, but I'd be willing to work with her to get that stuff back.
What? Oh, you marked right over there.
Wouldn't have to remember where we're at with the exhibit list, would you?
Where we are with,
Are we starting a new exhibit list for today?
yeah, start a new exhibit list for today because we have,
I think it'd be 123 based on the last exhibit list.
So 123. What says right on it?
yeah. Good job. Thank you. You don't know how many attorneys. Yes.
Exhibits for everyone and now I have one.
Well, no, that's okay. You have, you already have it pre-marked. It's definitely refreshing to have everybody organized.
Vincent, I'm showing you what we marked as exhibit number 123.
Right?
Do you recognize that document?
I do. It's a document that I made after I was inventorying the materials that she had left for me to pick up in the garage.
Okay, and there were some items, you recall, there were items that were agreed upon that you would receive, correct?
Yes,
And there are some items that are disputed.
yes,
And did you indicate on that list the items that are disputed as well?
I did.
Okay, so with respect to that list that you put together, how do we know which items are the items that it was agreed you would receive that you did not receive?
I marked on here on the side whether I was supposed to receive it or not receive it if it was disputed. And then I also marked if it was something I got or if it's still missing.
And are the items that you were to receive that you did not receive, are those in red?
They are.
And the items that are marked as being in dispute, are those in a particular color?
The disputed is yellow, and I guess I should stipulate that there are some in red where I received partial or damaged of those things. I signified it as red on the list because it's stuff that I felt like needed particular attention kind of thing.
All right, I need to understand. Red is received, yellow is not received, or it's the reverse?
Green is received.
Okay, I didn't see a green. Green is received, red is not received.
Red is received or not received or received partial or damaged.
Okay. Red is partial or damaged.
Judge, I
Or
think it
not
says right
received.
there on the
Yeah.
chart, does it?
Yes, I
don't have a
stipulate,
copy, so
Yeah,
don't
I just
know.
saw it on our family wizard, so.
Okay,
I made sure to communicate with Geneva the whole time about all of it.
all right, thank you.
And you said there were some items that were damaged?
Yes.
Okay, and tell me about that.
The blue couch, there was a pillow that was cut open. And then my desktop computer, there's a giant scratch right down the side of it.
Any other damage?
No, I think that's all the damage stuff. The rest of it is either I didn't receive or partial missing stuff.
And if there was a group of items that you were to receive, and there was only, for example, one item that was missing, did you specify that on your exhibit?
I did.
Now, I have a question, since I don't have that in front of me. Is that an entire list of items as the itemized list as exhibit number 12? Or is that different than exhibit number 12? Which, because I have a very complete itemized list with multiple items.
I think it is probably the same. I don't have
Here's
number 12 in front of me.
Thank you. Because I need to know what's different from this list versus what I'm being asked you want from exhibit number 112.
I think it's probably the same list. It's just updated with whether it's been received or not.
Very well, maybe. Yeah, I'm sure it's the same. It's just much smaller. Might need a microscope or, I mean, a magnifying glass.
Good eyes.
All right. So now Ms. Allen, I'm going to ask you, are you going to ask the court to rely upon exhibit 123 and to not rely upon exhibit 112?
Your Honor, I think that I would ask the court to, I mean, really, I think we need to review them together. I think mine is exhibit 112 and you have exhibit.
It's exhibit 112.
Okay, exhibit
Yeah.
112.
Minus the items, the first page of the non-marital property statement, minus that, pages 3 through 7 is what I am believing is the same as exhibit 123, just in a different format, and now with updated as to whether received damage or partial or disputed.
And so Vincent, are you comfortable having exhibit 123 replace exhibit 112?
I think that would be reasonable because it's the same list. It's just been updated.
All right, thank you. I just need to know what I need to rely upon.
Exhibit number 123.
And Ms. Moore, have you reviewed this exhibit?
It was provided to me in advance, no objection.
It is received. May I have it? Thank you. I don't yet need readers, but I might with this one.
I didn't know how else to get it all on one page. Those are all my questions, Your Honor.
All right, thank you, Ms. Moore. Additional cross.
Just briefly, Mr. Zilka, when you were asked some questions by the guardian ad litem, you were asked about your desires for education for the kids. And you said that it's your position that Chase, I'm paraphrasing, Chase should continue to be homeschooled, but the others should go to public school. Do you recall those questions at least?
I recall the questions.
And as it relates to the others, you had indicated that they should go to public school because then you and Geneva wouldn't have to discuss and agree upon the curriculum for them, correct?
That is not exactly what I said. My concern is that we have been unable to communicate effectively because she refuses to communicate back with me in a timely and effective manner. So it's best for the school to have the curriculum set up so that way there's no disagreement or fighting and the children can receive the best education possible. And that's part of my concern with Chase. And that's why I stipulated earlier that it was my position at the last hearing that Chase should still receive homeschooling. But since then, I sent an email to Renee about my concerns with Chase still doing homeschooling because there was no stipulation as far as like how much work he should do, which courses or anything like that. And it leaves too much open to question. So I have concerns about us being able to do that because she refuses to communicate with me.
The agreement was Khan Academy, yearly testing and a reading supplemental program, right?
It was, but Khan Academy is a big format. And so what portions of Khan Academy is he supposed to receive on a daily basis? How much is he supposed to learn? Which units or topics?
So are you changing your position as it relates to Chase?
I am addressing a concern that I have about this position. And it's one that I feel like needs to be addressed before I can formally agree to it.
So again, you understand at the last hearing, we put a stipulation on the record with Judge Moken. You
I do.
recall? Okay. And now you're saying you need more questions answered before you can maintain your agreement to that?
And she hasn't even started educating him on it. So I don't see where my position has changed anyway, other than I'm concerned with the fact that there's things left open to question about how much education he should be receiving on a daily basis.
Do you understand today is the final divorce hearing?
I do.
And today is the day where Judge Mogan needs to know what you're asking.
I would ask that we stipulate specifically what Chase should be doing, or that it should be stipulated by someone outside of us, like the guardian ad litem or something like that. So that way we don't have to go back and forth, because there's no way for effective communication when only one side is willing to do it.
And that's you. You're the good communicator.
I'm not going to say I'm a good communicator, but I'm making the best effort.
So if the guardian ad litem has a specific recommendation on which modules or which programs through Khan Academy are to be used, then you believe you guys will be able to work this out for Chase.
I believe so.
And the same would hold true then for the other children.
I believe it's in the best interest for the other children, because they're at an appropriate age and time frame to receive public education, where Chase is so far behind. Whereas if he were put into public education, it'd be a lot more of a struggle. I'd be open to exploring, and it's something that I've talked about, is Chase doing a form of public education. So that way the curriculum is decided for us. So that way we don't need to worry about the disagreements.
And you had the same concerns when Vivian started public school.
I had different concerns with Vivian. It wasn't about a lot of it. Actually, let me correct. Sorry. Can I finish?
I think you did. So thank you. Since the last hearing, you've continued to work Fridays, correct?
I have continued to work Fridays.
And there was some discussion at the last hearing about who was watching the kids on Fridays and whether or not Geneva could or should be doing that.
There was, it was brought up that she should, or we should have the right of first refusal for both of us. And it was asked that I do that. And so I have provided that to her since then. And she has asked that she watch the kids on Fridays.
Okay. And you've been doing that?
I have always been trying to be as, work with her as much as possible.
For the few Fridays that this has happened, what time have you generally dropped the kids off with her?
Typically 6:30 in the morning.
And then what time do you generally get back to pick them up?
It's been about 2 o'clock in the afternoon.
And if I recall from your testimony, last time your Fridays, you get done a little bit earlier.
I'm able to adjust my schedule should I need to, because I can do work from home still.
And so what time, if you know, does the bus pick the kids up from your house?
I think it was 7:15,
How far do you live from Miss Zilka?
5 minutes.
So bus times would be pretty close.
Don't remember what her bus time was.
Do you know what time the bus would drop them off at your house?
At my house, it would be about 4:30, I think.
And your testimony at the last hearing was that you would leave for work at about 6:30 or 7 in the morning and return about 4:30. Does that sound accurate?
I believe so. And I can, like I said, I can tailor my schedule a little more, just let the students know, hey, I'll be pushing class to a certain point, so that way I can make sure the kids are always on the bus every morning.
Does Vivian ride the bus to school from your house now?
No, I drop her off with the boys to Geneva.
And then she buses from Geneva's house to school?
Yes.
I want to shift gears a little bit and talk about your Jetta. The 2015 Jetta that you hit the deer with, it sounds like you've received a partial insurance check. Is that right?
No, I have not received any checks for the Jetta. There is no insurance. We had liability only, so the insurance will not cover anything on that vehicle. The insurance payment that was received was a refund for the insurance payment that was made on the house in Arizona.
Thank you for clarifying. So the $955 was a refund check for the Arizona house.
A partial refund. We should receive more, but we're waiting for farmers insurance to go through their end to understand why we only received a partial.
And are you going to be depositing that in Attorney Allen's trust account then with the balance of the proceeds?
I'm willing to do whatever is agreed upon. I brought it here specifically for that purpose.
And you testified then that you purchased a new to you vehicle. What did you purchase?
2013 Chevy Cruze.
And what is your specific proposal for the court regarding your Jetta?
That it's looked at as the same as her Oldsmobile or my Matador and the negligible value.
You want to keep it?
For now, I'm going to decide what ends up happening with it. I'm not sure. Probably just end up scrapping it.
Can you use parts from that for any of your other vehicles?
No,
Not compatible?
it's a different make model.
Sure.
The only thing I'd potentially be able to use is some of the fuses.
And I believe that is all the questions that I have.
Landgraf?
Thank you, Your Honor. Vincent, when you came home in January, the kids were doing the easy peasy homeschooling with Geneva,
They were.
and you, on your days, you supplemented that with Khan Academy with the kids,
I did.
and you chose those programs and supplemented it on your own.
Typically, I'd work with the kids and see what they wanted to do that day. And then I'd look at the units or the modules and decide how many of them they should do per day based off of a reasonable workload. And I feel like it was important to keep like one unit like whole kind of thing. So if they, when I looked into it and the module was like all math or something like that, I try and keep just the math together instead of doing like a portion of the unit in math and a portion in another subject and a portion in another subject, because they're able to focus on one subject in that particular unit and learn the whole thing cohesively. And then sometimes I'd add on another unit from another subject because there wasn't enough in one.
That answers my question. How many subjects at one time do you propose Chase uses on Khan Academy?
The way it's set up is you can differentiate it based off of grade level. So he can go in there or we can go in there and look at which subjects we want him to learn. So math, science, there's music, there's a number of other things. And basically I tried to work off of the recommended grade level and have him do as many of those subjects as possible during my time.
No further questions.
Let me step down.
Your Honor, may I have,
We are like, this is going and going and going and going, and I think we can go forever. So 2 questions. That's it.
all right, Vincent, you had the children evaluated, correct?
I did.
Sylvan, and it's fair to say that all of the children evaluated way below what their current grade level should be.
The only one that didn't was Aiden because he's not even in a grade level right now.
And does their performance on these Sylvan evaluations, which are exhibit number 113, also influence your position regarding the public school education for the children?
Absolutely.
And we are not getting into anything I have not heard before.
And those are all of my questions, Your Honor.
All right, Ms. Moore?
Nothing.
Ms. Landgraf?
Oh, Your Honor.
You may step down. Thank you. All right, we have kind of like went back and forth and hopped with witnesses, but I think we are on Ms. Allen. Do you have additional witnesses?
Just two that should be very brief, Your Honor.
All right.
I call Jesse Gross.
Name
Mr. Gross,
again.
could you please state your full name for the record?
Jesse Dwayne Gross,
And could you spell your last?
Gross,
And Mr. Gross, where do you reside?
Milltown, Wisconsin.
And do you know either Geneva Zilka or Vincent Zilka?
I have known Vincent for about 20 years.
And how do you know Vincent?
We served in the military together.
And over this past year, have you had the opportunity to observe Vincent with his children?
Yes.
And where did that occur?
No, it happened at my house.
And on how many occasions have you had the ability or the opportunity to see him with the kids?
I haven't been keeping track, but it's been periodically throughout the summer.
And why are you seeing the children at your house?
My wife has been watching the youngest two for Vincent while he's been at work.
And during the times that you've had the opportunity to observe Vincent with the children, what have you observed?
The kids always appear to be excited to see him, and it seems to be a very good relationship.
So do they appear excited when he gets there?
Yes,
Do they appear comfortable with him?
absolutely.
Have you seen them play or do any activities together?
Not so much, because when he's been picking them up, he's been picking them up from a daycare facility, so to speak. So he's got things to do. We have things to do, but nothing seems out of the ordinary.
And how long have the interactions been that you've been able to observe?
Anywhere from 15 minutes to an hour and a half.
And during those times, have you ever had an opportunity to perhaps see him discipline the kids?
I wouldn't really say discipline has been necessary.
Have the children ever been in a stage of being upset or anything of that nature when he's been there to pick them up?
There's been times when he's picked them up and they've been overexhausted or overwhelmed, and they've had some mild meltdowns, but things have been handled appropriately in a reasonable time frame.
And what do you mean by handled appropriately? How have you seen Vincent respond to those?
He usually gets down on their level and talks them through their emotions and settles them down.
Have you ever seen him yelling at the kids?
No, absolutely not.
Would you describe him as being soft-spoken?
I would say that, yes.
Were there ever any incidents that you observed between Vincent and the children that caused you concern?
No, everything seemed to be, very appropriate, not out of line in any way.
Those are all the questions I have, Your Honor.
All right, Ms. Moore.
Thank you, Mr. Gross. I want to make sure I understand your testimony. I believe you said you've known Mr. Zilka for about 20 years,
Correct.
and that your observations about him at pickup drop-offs, that's been within the last year.
Yes,
How long has your wife been watching the younger kids?
throughout the summer.
So summer 2024?
Correct.
And is it Monday through Friday, or what days of the week?
It was usually on Fridays, but she has watched them other days of the week as well.
So Fridays were the more consistent day?
Correct.
And so is she still watching them on Fridays?
Not currently, no.
How long has it been since she's been watching them?
I think the last time she watched them was middle of September.
And so during that time from summer, whenever that started, until maybe middle of September, primarily you were seeing him briefly at pickups or drop-offs or both?
Primarily pickups.
Pickups. So the afternoons you would be home when he came to pick up his kids.
Yes.
Didn't see him much for morning drop-offs?
I usually sleep in a little bit on Fridays. I work long hours during the week.
Okay, so more so in the afternoons, and I think you said maybe 15 minutes, maybe an hour and a half, some period in there.
Correct.
Have you ever met Miss Zilka?
I don't believe so.
Have you ever seen her parent, her children?
I don't recall.
Have you observed the children with Mr. Zilka prior to this year?
No,
Have you observed the children prior to this year?
no,
So the first time you met them was this summer.
correct.
No other questions?
Ms. Landgraf?
No, Your Honor.
All right, any redirect?
No, Your Honor.
You may step down. Thank you.
Thank
You
you.
are free to leave. Next witness.
I'll call Michael Zilka. Mr. Zilka, could you please state your full name for the record?
Michael Charles Zilka,
And Mr. Zilka, what is your current address?
Hot Springs, Arkansas.
And how are you related to Vincent Zilka?
He is my son.
And so over the past year, so first of all, I just want to ask you over what you've observed over this past year. Okay, so we're just talking 2024 right now.
Okay,
So you live in Arkansas, is that true?
that's true.
Okay, so how frequently are you able to visit here in Wisconsin?
I've been up here 4 times already this year.
And how long are your stays?
They vary from a week to a few days.
And where do you stay when you are here?
We stay with my daughter, Valerie,
And where does Valerie live?
Timber Grove Heights.
Now, during these, so let's talk about the very first visit that you had in 2024. Do you recall when that occurred?
It was in August.
And how long did you visit?
I believe we're here 2 weeks.
And during that 2-week time frame in August, did you have the opportunity to observe Vincent and the children together?
Yes,
How many times?
I believe it was twice.
And how long were the visits?
They vary, normally about 3 hours or so.
And during that first visit, that first August visit, what did you observe between Vincent and the children?
If I remember right, they came down to my daughter's house and we sat and played around a little bit with the kids, watching Vince with the kids.
And what did you see?
I'm actually amazed on how good a father he is. He is very patient and tries to keep the kids under control. He does a really good job.
What did you observe them, if anything, doing together?
A lot of times, when they came down to Valerie's, it was just more or less they were just sitting and socializing. There wasn't a lot of interaction. It was more of a social visit where we just all got together and there wasn't a lot of going out and doing anything that particular time.
Have there been other times when there's been the going out and doing things?
Yes, we'll go out for dinner. We'll do we went to parks and stuff like that before also.
Have you seen Vincent playing with the kids?
Yeah, the one time we're they're at Valerie's and she's got a park just down the street. We go down there and play. We're playing, it started out playing on the merry-go-round, stuff like that, and we end up playing ball together.
And so when they were at the park, was Vincent just sitting watching the kids, or was he actually
No,
interacting?
He was interacting. We're all taking our turns up to bat and stuff like that.
Have you seen Vincent doing anything else with the kids?
A lot of times the little guys, Aiden and Evander, they like using dad as a jungle gym. They like climbing on him and just being with him. They like to roughhouse a little bit. He's very patient and the kids just love it.
Have you observed any time when Vincent needed to discipline any of the kids?
He has told them that, you got to take your turn while we're playing baseball. One kid or the other would say, "Oh, I want to go now." It's like, no, take your turn. Just sit and be patient. You got to take your turn in the outfield and stuff. And before you can take your turn up to bat. It wasn't a actual punishment. It was just a teaching thing for taking your turn along that line. It was more of somebody wanting to jump in front of the other ones. So it wasn't, like I say, that particular time at Valerie's, there was no real need for any discipline or whatever. There has been other times where he's basically told them, well, you need to sit down and like take a timeout type of thing.
Have you, during those times when he said they needed to take a timeout, has he been yelling at them?
No, Vincent never yells. Me, that's a different story. I think he found where I was not. He's seen the things I did that he didn't like. And just like every parent, I'm not going to do that to my kids. And I would have a tendency to more raise my voice with the kids when they're doing something wrong. Vince never raises his voice. He's always cool, calm, and collect, almost to the point of being too passive in my eyes. But every parent has their own parenting skills.
And was there, were you there when Vivian went to the father-daughter dance?
Yes. It was kind of funny because we're supposed to go up there and he said, well, when can you get here and stuff? And we told him what we were doing because we were going to watch the boys. And he basically took all day going shopping to get different outfits for for Vivian to wear. And she had to model them all. I think she had like 4 or 5 different outfits and shoes. And it was like, okay, that's a Halloween costume. That's not appropriate for the dance. And it was so funny where, she really didn't seem like she wanted to go in one sense, but in the other sense she did, but she wouldn't get ready to go. And I think her grandmother and I got a little more worked up than Vince did and stayed cool, calm, collect the whole time. And she said, well, I don't want to wear this. I'm going to wear my pajamas. It's like, no, Vivian, this is a formal thing. Look at your dad. He's in a suit and he looks really nice. You don't want to wear pajamas. And
So that's what you were thinking, or did you say that?
oh yeah, this is what,
And so what did Vince do?
he stood there and said, well, I'm ready to go, Vivian. Are you coming or what? And finally, she went in her bedroom and she dressed into her nice dress that Vince got her, and she looked very nice.
And did they end up going then?
They went and she come home and she was very excited. She ended up having cookies for everybody, for her other brothers. So it was really kind of nice that, she thought enough to get treats for her brothers that couldn't go to the dance. I thought that was really sweet of her.
And is that, in your thought, kind of exemplify how Vince handles the children if they're having a tough time?
It's a nonstop for him. I wish I could have been as calm and collected as he always seems to be.
And during any of your visits this year, did you have an opportunity to see or speak with Ms. Zilka?
I seen her once. We didn't talk. Well, I suppose I said hi to her the last court date, but the only other time I seen her was at Vince's house. She was dropping the kids off, and she stopped out in the side of the road and was proceeding to have the kids get out of the car in the middle of the road and took their stuff and just threw it in the end of his driveway. And it's just like, could have waited. We could have carried it down. Now it's all dirty. It's got to be cleaned. Just to be able to go back into the house.
So was there a driveway that she could have turned into?
Yeah, he's got a long driveway. He could have pulled in, even if she didn't want to go all the way up to the house, just come part of the way in. So I understand that his road isn't very busy, but all it would take was just one car flying down and one of those little ones to get hit. And it just, I couldn't believe that she would do that. But that is the only time that I've seen her, other than the saying hi to her at the court last month and a half ago.
Those are all the questions I have, Your Honor.
Thank you. Ms. Moore?
Mr. Zilka, I want to touch base just briefly on that last comment you made regarding the one time that you've seen Ms. Zilka this year and your impressions of how the drop off went. You're familiar with that incident?
Yes, ma'am, I am.
When was that?
That was the day that he was able to get his truck out of the driveway. The exact date, I don't remember what it was.
You remember a month?
It's August, probably maybe September.
And your impression was that she should have handled the drop off differently, correct?
Correct.
You've also shared that you probably would parent different than your own son does, right?
Correct.
And you don't know what information has been communicated between the parties or through counsel or by this court or others regarding drop offs and exchanges. True.
Correct. I do not know.
I have no other questions here.
Ms. Landgraf?
Just a couple, Your Honor. Mr. Zilka, I'm sorry, you live in Missouri?
Arkansas.
Arkansas, close. And how often do you come up to Wisconsin to see the kids?
It depends. When Vince was out of the state, it was probably only about once a year.
So while Vincent was living in Arizona, you saw the kids about once a year?
Correct.
And then before he went to Arizona, how often did you get to see them?
Well, that depending on where it was, because there was a time where Geneva wouldn't let us see our son or our grandkids for about a year and a half. She basically alienated us
Section.
from.
Foundation speculation.
There's no speculation. It's the facts.
Mr. Zilka, you have to wait until I make a ruling on whether or not.
I'm sorry.
That is. Basis of foundation.
he's testifying as to what my client did and why, and he can't. He doesn't have the foundation.
I'm gonna overrule it. You can answer. Can answer as to what you stated and your belief as to why.
I believe she alienated us for the simple fact that earlier, when going back to when we first met Geneva, we were walking in Pine City, and me and my son were walking, and Geneva and my wife, Geneva and my wife were walking right behind us, and she had made the comment that how she alienated her father, Chase's father, and grandparents from seeing the kids. She made the comment that she had come up with excuses that Chase was sick or she was busy or whatever and couldn't see the kids. And that kind of led me down the path of, oh, she's going to do that to us also. And that's where I came up with the conclusion that not being able to see our grandkids or our son for a year and a half is where I feel that she was trying to alienate us also.
What time frame was that?
It was approximately about 7 years ago.
Did you ask Geneva if you could come up and see them?
We weren't even allowed to talk to them.
Did you talk to Vincent?
We weren't allowed to talk to him without having her present. That was basically what we were told. So it took, like I say, a long time before they even let us talk to him or the kids.
Okay. I don't have any other questions, Your Honor.
All right, Ms. Allen,
And no additional questions, Your Honor.
Ms. Moore.
Who told you you couldn't talk to your son?
Geneva did.
Geneva told you you cannot talk to Vincent unless I am present.
They sent it in a text.
Who's they?
It was on the phone, so exactly who sent it, I don't know. If it was Geneva or if it was Vincent, and I can't believe after the comments that Geneva made, it had anything to do with Vincent.
So you don't know who said that?
Not exactly, no. You can't tell who wrote a text.
You're saying there is a text from Geneva to you saying that you cannot have contact with Vincent unless she is present.
I have a text from them, whoever it came from, saying that we were not allowed to talk to our son unless Geneva was there.
But you don't know who the them is in that sentence.
No, I do not.
No other questions.
Ms. Landgraf?
Nothing further.
All right, you may step down. Thank you. Any additional witnesses, Ms. Allen?
No additional witnesses, Your Honor.
I believe the matter should be closed then for evidence and testimony.
It could be, Your Honor. I would like to call Geneva Zilka for rebuttal as petitioner. I understand if Your Honor doesn't allow it, I appreciate the time constraints, but I do have just a few questions for her on matters that were testified to today.
You have until noon.
Then I'd like to call Geneva Zilka.
All right, Ms. Zilka, please come forward. Remember, you are under oath. Come have a seat at the witness stand. You may begin.
Thank you. Ms. Zilka, first state your name for the record.
Geneva Zilka.
You understand you're under oath today?
I do.
I want to start with the last comment from Michael Zilka. Did you text him and say that he could not have contact with his son unless you were present?
No, I did not.
Did you prevent him from having contact with his son?
No, I did not.
Did you tell him or his wife that you had alienated Chase's father from his life?
I have never discussed Chase's father with his parents.
With Mr. Zilka's parents?
Yes.
Had you said anything that they may have construed in that fashion?
No,
Is it your intention to alienate Mr. Zilka from your children?
absolutely not.
And I'm gonna have you be more specific, which Mr. Zilka?
Is it your intention to alienate the children that you have with Mr. Vincent Zilka from Vincent?
It is not.
Do you want your children to have a good and healthy relationship with their dad?
Yes, I do.
Had you and Vincent Zilka had conversations about his parents' involvement in your children's lives?
Yes, we have.
During the marriage, you guys talked about what input and what contact they would have. Is that
Yes,
fair?
we have.
Did you feel like you and Vincent had an agreement?
We did have an agreement.
Did you do anything to your knowledge to undermine the agreements that you and Vincent had about the involvement of his parents?
No, I did not. He facilitated all of it. We discussed it, we agreed upon it, and he engaged with his parents.
So he was the one communicating those boundaries to his parents?
Yes.
I want to go back. There was some new testimony today about Vincent Zilka and the vehicle that he had at the last hearing being in a auto deer accident, correct?
Correct.
And he testified that he tried to communicate with you about that accident, about replacement, about the use of the van. You recall that testimony?
Yes, I do.
What is your position on the communication about the use of the vehicles?
I had reached out to you, pretty much asking questions, trying to get things resolved. And as soon as I figured out how to handle the situation, I let him know. And at the next exchange, he picked up the vehicle for the kids and him.
The vehicle being the black
The
van?
black van, yes, correct.
So he could use that while he was searching for a new vehicle?
Yep.
Did you intentionally delay responding to him?
No, I did not.
You had some legitimate questions about how it would work, is that right?
Yes, I did.
And after you and I were able to communicate, you communicated with him through our family wizard?
Yes, and that included talking to you about trying to get him finances to buy a vehicle. There was discussion being had and I was trying to work it out.
Sure. And so I think initially it was trying to communicate on what vehicle he would purchase, and you then authorized him to just buy whatever vehicle he deemed appropriate up to $10,000.
Yeah. He wasn't involved in our discussions, but I was discussing with you on how to deal with the situation. So yes, I was dealing with it.
And then you responded with that authorization back to him directly.
About taking the van and about releasing funds out of the trust account?
Yes.
Correct, yes.
His position today is that he is asking that he be awarded that Jetta and that it's essentially totaled. Is that, do you agree with that?
I don't know. To be honest, I would. There's value to a vehicle, an insurance company would have paid out possibly to buy it type thing. I don't know what the value is, the estimate on the vehicle, I don't know, but
Do you agree with him receiving the vehicle?
yes,
And if it's assessed a similar value to some of the vehicles being awarded to you with nominal value, does that seem appropriate?
yes,
Not something that you want to fight about?
no,
Regarding the proceeds from the sale of the Arizona property, at the last hearing, you had proposed a property division which would result in Mr. Zilka paying you an equalization payment, correct?
yes,
And ideally, you had those funds that could be used for an equalization payment or something to make the property division equal in the end, correct?
what was that again?
You appear confused, so let me
I am.
rephrase the question. You had intended that the funds from the sale of the Arizona property could be used to make you whole in an equalization payment. For
Yes,
Mr. Zilka, instead of him having to come up with cash to pay you, those funds could be transferred to you in lieu of Mr. Zilka paying you cash.
yes,
You've also given a little thought to the current debt situation and potentially using those funds to pay off some debt, specifically some credit cards of the marriage.
Yes,
You agree that the credit card debt is marital debt?
yes,
It was incurred during the marriage?
yep.
Is it your incentive that you're removed from those debts at the conclusion of this divorce?
Yes,
You need that off of your credit report moving forward?
yes,
And so whether the court uses the funds in trust to pay off some credit card debts first and then uses it for an equalization payment, or sticks with your previous position of just using it for equalization, those are your requests for the funds from the sale of the Arizona property.
yes.
Your Honor, do you have Exhibit 123?
I do.
May I approach?
You may.
Geneva, I've handed you what's been marked as Exhibit 123 today. This is that list of personal property items that Mr. Zilka compiled. You've seen that list, correct?
Yes,
Now, there are items that he's indicated he received some of, or they were damaged, and I believe those are highlighted in red. Do you agree with his annotations on those items?
I guess I have question because I think what's in red, I guess depends on what you're talking about because there's a couple different things. I don't,
So the items in red, I think, for example, the first one is Tonka trucks, if I recall.
I don't know if this is a complete list. It starts off with a tractor seat for me on page 1 and then something's missing here.
Your Honor, do you have any other pages of Exhibit 123?
No, I gave you 2 sheets and that's, I believe it.
I don't see the Tonka trucks on this page.
That's the same one you gave me. That one had Tonka trucks first.
That's all it was 2 sheets.
It's on this 3rd page, sorry. Yes, the first one is the Tonka trucks, yes.
Okay, and so that is highlighted red and says missing, correct?
Yes,
So as I understand it, the red highlights are missing or only partially received. Does that appear accurate?
yes.
Do you agree with the items listed in red, or are there items that you disagree with?
I guess I don't know what you're asking for sure, but like the Tonka trucks are not in the home and I did not remove them from the home. I have absolutely no idea where they are. So like, I don't know what you're asking.
Are there any items highlighted in red that are still in your possession?
The old spoons that were white and are now yellow. I gave him the one of the 2 that was still in the home. The other one was broken. It's a spatula, essentially a scoop. I don't know.
Did you intentionally break it?
No, I didn't actually. Our son was cooking and it broke, so I didn't have, but yeah, it's the white casserole dishes.
Do you agree with him receiving the white casserole dishes or not?
Honestly, I don't really care. They were mine. I don't even. If it's going to end things, he can have the casserole dishes. The heavy plastic box on the deck is something Chase has been using for approximately 3 years, and I'm looking for something to replace it for him, and then he can have it back. Chase he stores his sports equipment in it on the deck. So I didn't communicate that to Vincent, but that's one of the things I'm trying to get figured out. As far as the motorcycle lift, I would like to keep that. He's essentially taken everything else, including the floor jack that we had for the vehicles, everything. I also have a motorcycle and have use for it. The missing tool set his son has been using, I don't know where it's at when it comes about or appears. Chase finds it, I do, we'll get it to him. As he says, probably other tools missing. Anything I see in the home that's his, I will get to him. I'm not trying to keep things from him at all. Supplies for the air compressor, I did not give to him because the air compressor was disputed and I would like the supplies to stay with the air compressor. The miter part box, I don't know what that even is. The ammo, I gave him all of the ammo aside from what I can use myself in one of my guns. That was the intention with whatever ammo he said wouldn't work for my guns. I had the wrong one marked. I gave him everything else. I gave him all of his ammo, his weapons, everything. I don't know what I have nothing left for that. The desktop computer, I never even touched myself personally. It was in a closet in the basement. A friend of mine grabbed it, walked it upstairs, set it down. I took pictures of him doing so. I did not touch the computer. I did not damage anything. The Lego bin cover, the flat Lego bins. All the Legos essentially were combined at some point. I went through and pulled out a good majority and gave back to him. So I don't even know what Legos would have been in a bin at one point when we originally got married. But I gave him the bins back and I gave him Legos. And then, I guess the damaged couch, the kids, it's in the basement, the kids and everybody uses it. I didn't damage the couch, but otherwise, yes, in the red.
And generally, the items that are annotated disputed, you've touched on at the last hearing, and we don't need to belabor those.
No, those are fine.
Your Honor, then I have no other questions for Geneva.
All right, Ms. Allen.
Geneva, I'm going to just ask you questions in order that your lawyer did, okay?
Okay.
So one of the first areas of questioning that she had for you had to do with the vehicle when Vincent was in the accident. And so did Vincent notify you on our Family Wizard about the accident?
Yep.
Okay. And did he tell you that he's going to need a vehicle to use since his is no longer functioning?
Yep. He said he'll need a vehicle to use with the children.
Sure. And you understand that pursuant to the temporary order that's in place, he does have the right to use the black van.
Mhm.
And so,
Can't answer. You have
Yes.
to answer yes or no.
Yes, thank you.
and so, and rather than responding to Vincent right away to say, you can use the black van, you had to call and talk to your lawyer about it first?
I had to make sure that that's still in place, the order, the situation. I was verifying, yes.
But even if it wasn't in order, you understand that he would need a vehicle to drive the children.
Yes. He didn't have the children, I had them.
So I
I-
guess what I'm not understanding is why you needed to talk with your lawyer to find out about whether you should let him use the black van. Wouldn't that just be a common sense thing to do?
Well, and the other question is too, does he need the van all the time? Does he need it with just the kids? I mean, how does it all work? Because initially, when we had issues with vehicles, I let him use the van when he had the kids and then I got it back. So
And
I
so
had to,
You're talking 1,000 miles a
Sorry.
minute and my court reporter, her hands are on fire. So you got to talk slower.
thank
Okay.
you, sorry.
And so did you ask those questions of Vincent?
Ask him,
When is he
Whether-
going to need it? How
He-
much time is he going to need it?
he asked me, he told me he needed it for when he has the kids. So I was verifying with my attorney how that all plays out. And then I also discussed with her because I know he needs a vehicle and I want access to my minivan because the 12-passenger van gets 13 miles to the gallon. It's rear-wheel drive and not the most comfortable thing to drive in the winter. So I had called her and asked her about, is there a way we can get him so he can get a vehicle as soon as possible?
Slow down. You
Sorry.
talk really fast.
I do. I talk really fast.
If I can't understand you, my court reporter can't understand you, so she can't take you down. Okay? And she needs to be able to take all of this down in a transcript, just in case. Okay? So maybe causing a little bit of anxiety to sit in the witness stand, take a deep breath, and then respond. Okay?
Okay.
With respect to the personal property items on exhibit number 123, you indicated that there are some items that you can't find or you don't know where they're at. Is that accurate?
The Tonka trucks.
Do you agree that if you would find those Tonka trucks, that you would provide those to Vincent?
Oh, yes, they're his.
Do you agree that with respect to any of the other items that are marked in red on exhibit number 123, that if you would find them, that you would provide them to him?
Yes, I will.
And you've agreed that he can have the white casserole dishes?
If that will end the debate, yes.
Those are all the questions I have, Your Honor.
Ms. Landgraf.
Thank you, Your Honor. Geneva, has Vincent come over to the marital home where you are without your permission?
Yes, he has.
And have you expressed to him that you don't want him to come on the property?
Yes, I have.
And he has come on the property after you told him?
Yes, he has.
Towards the end of November, well, November 25th to be exact, did you inform Vincent that he needs to get toothbrushes, hairbrushes, floss, all of that kind of stuff for his house?
I had asked him to get some things the kids had been asking about, yes. They generally ask me to get stuff, and I continue to let them know that with Dad and the new changes. They do need to discuss that with Dad, and some of those were discussed with Dad.
Okay. And he did respond to you along the lines of that he's trying to get everything set up with the kids that they need?
Yes.
And that he doesn't have the luxury of having places for everything yet, and they're still learning how to, I guess, operate in the new house.
Yes.
Would you have any issue with Khan Academy if Vincent picked out the math and science courses for Chase and you picked out the other classes on Khan Academy with Chase's input, of course?
No, I wouldn't have an issue with that.
No further questions.
All right, Ms. Moore.
Nothing, Your Honor.
Ms. Zilka, has the Khan Academy instruction begun yet?
I haven't started it. I've discussed it with our son, and we've talked about moving forward with it, if that's what's ordered in the court.
But it's true, you recall at the last hearing, everyone stipulated that that's what you would be doing.
Yeah,
But even so, that hasn't started yet.
no, I mean, his math does use Khan Academy to a point, but no, we're going to switch over to Khan Academy and the reading program. Yes.
When are you going to do that?
I figured over the Christmas break would probably make it easier to transition into something new. I've discussed it with Chase because the way Dad was doing it was an entire unit, which could take him up to an hour and a half for the math. And it's kind of confusing to him because he somewhat likes that, but it makes it hard because I do more topics. When homeschooling, it's not just covering math. There's reading, science, language, art. There's he has earth science. He has typing class. There's a bunch of stuff. So an hour and a half of math doesn't always fit well. And a unit is intended, Khan Academy is kind of to work at their own pace. And it's intended, to work, that works for them, but to get a little bit in and not do an entire unit a day. So I know Chase and I have kind of discussed that, and he struggles because Dad did this, you do that. I mean, so we talk about it. A lot of things are discussed, not just kind of thrown out at him.
Now, you were asked about Vincent coming over to the house recently.
Yes.
When did that occur?
After the last hearing, he had showed up to bring something to Vivian, is what my understanding was.
And is it your understanding that, or did you and Vincent communicate about what happened? in
No,
that event? Did he explain why he thought he had permission to come to the house?
from my understanding in the Our Family Wizard is that that was after Vivian's counseling, and she was really upset about the dog and not being able to see the dog because it was my weekend. And her and I discussed getting together Leela's stuff to bring to Dad's when they go there, or to put in his stuff in the garage so he could pick it up on Friday.
So she came home from counseling and she was sad because she wanted to see the dog.
She wanted to be with Dad on my weekend because that's when he was getting the dog.
Okay.
So
So did he come to the house then?
later that day is when I came out of the bathroom and he was on the road with 3 of the kids in the car.
And what were they looking at, the puppy, or what was going on?
From my understanding, he was dropping something off to her, and the stuff we got together to put in the garage, she brought out to him.
So he was in the street?
Yes, he was in the street.
He didn't go into your driveway, correct?
Correct.
He was in the street and the kids came to see him in the street
Yeah,
and he was dropping something off for Vivian.
correct. And then he came back again after that for something, dropped something else off or something. I don't know.
But he didn't have the dog.
No, that was Wednesday. He was getting the dog on Saturday.
And do you know, does he still have the dog?
As far as I know,
Those are all the questions I have, Your Honor.
Nothing. All right, you may step down. Thank you. You have any rebuttal? Is it necessary?
No.
I'm gonna tell you, I didn't mark my pages, but I have this much notes, lots of notes. So listened very carefully, took very detailed notes. We have no other witnesses.
Correct.
The court is receiving all offered exhibits. I have received exhibit number 123. What I'm going to do here today is hear guardian ad litem recommendation. If it has changed from the guardian ad litem's written recommendation provided to the court from October 14th, 2024, I will hear closing arguments from counsel. And then, quite honestly, I am not going to provide any, I will divorce them here today, but I'm not going to do any decision today because I have a lot to digest. I will most likely do a written decision, and I do them very quickly. Ms. Landgraf can contest to that, or not contest. She can state that I do. Very quickly do I get out my decisions. But in a case like this, not only will I do a written decision, but I am going to do an oral ruling because this is a very hot and heavy case. I see a lot of discord in this divorce, and in discorded divorces, I like to have parties present so I can go over some key points with them as it relates to divorce, and particularly as it relates to the children. Therefore, I will have an oral decision, an oral ruling, and then at that time, I will hit click and sign my written decision, and you will receive it right after I make my oral comments and rulings. So at this point, I'm going to turn to Ms. Landgraf, and you can provide your recommendation and let me know if it differs in any way from the written.
Thank you, Your Honor. I will just go page by page. I'm definitely not going to read anything. I just want to point out a couple things that I want to add or change a little bit. But I want to start off by saying that my recommendation obviously doesn't adopt either parent's proposal to the court. And I know it's a little bit particular, but I think that with the complex communication between the parents, I think there needs to be a more detailed placement schedule than maybe some other cases. All 4 of these kids are completely bonded with either parent. I mean, they're bonded with both parents. I've seen that in person. You could just tell that from the kids when they talk. So I don't think that's an issue at all, that they're not bonded with dad because dad was gone in Arizona and he's come back. I don't think that that's an issue at all. So on page 2, I did list out for the school year where the kids would be with Geneva during the day if Grantsburg's not in school and dad has to work. I also said that Chase should be with her on Vincent's weeks, even when he goes to work. I do think it would be a great idea for Chase to go with his dad to work, but not every day, not every 5 days, every other week. Maybe on the weeks that he does work during his placement, he can take Chase one of those days to work, because I think it would be great for him to get exposure to the different types of things that are going on. But not only would I think that would disrupt his schedule, but I mean, it's an hour drive back and forth. I don't think that would be appropriate for him. I think that the schedule provides consistency for the kids. It eliminates the need to arrange other childcare in case the kids are sick. It also eliminates the need for a right of first refusal. We heard testimony that the kids, they've essentially been with mom the whole time, unless they were in Arizona with dad, and then dad comes back and he gets the kids on most of the Fridays, and then they're going to somebody else's house. I don't think that that's appropriate either, because they're used to being with mom. So I think that this schedule kind of reduces the conflict that goes along with where the kids are going to go when Vincent is working. I think we can eliminate on page 2, number 2C, for the winter break. I think we can just eliminate that altogether. Dad testified that he has like the whole month of December off. So I think we could just change that. And I added a section on by Christmas. Page 3. I don't want to make any changes to. I know the holiday schedule is not the typical alternating days and years, but I think that this schedule gives the holidays like Veterans Day and Memorial Day to dad every year, so they can create traditions. He's a veteran. And then also but Bob can still have the traditional Christmas Eve, Christmas morning, because Vincent, I believe, testified that he doesn't really care about the day. He just wants to be able to have time with the kids around the holiday. On page 4 of 5, the first one, number 9, in addition to mom having every year from the 23rd to the 26th, I'd like to add that dad have the kids from December 26th at 4:30 p.m. to January 1st at 4:30 p.m. every year. Obviously, the kids and Vincent will both be on winter break, so I think that is a great week for them to be able to spend together. I've already expressed about school, that Chase should be able to go with dad one day during his week. I think that dad should choose the math and science courses on Khan Academy to do with Chase. It is obvious from his background of where he's been working and what he's doing now. It seems to all center around math and science. I think that he should pick those courses, and then the remaining courses, the electives and the reading and everything, I think mom can be the one to pick those with Chase's input. And I didn't ask Vincent that on the stand, but mom does agree to that. One of the bigger issues is Evander and Aiden, whether they should go to traditional school or if mom should continue homeschooling them. I recommend that they do go to the traditional schooling. Vivian she's older than them and she has transitioned nicely into public school. I don't think that these two younger boys are going to have any issue with transferring into public school. I think it will reduce not all conflict regarding the school, but I think it will reduce quite a bit of conflict between the parents. And I think maybe the biggest thing is that the kids all do have poor testing scores. I mean, that was an objective third-party report that came in, and, Chase and Vivian are older and they've been homeschooled, believe their whole life. So I mean, just the grades in itself, I think that they should transition to public school. of course, if something happens and completely unexpected, I did recommend at the end of this that the court should order this as temporary order for 9 months before it becomes a final order, just in case something does happen where we would need to amend that. I think everything else stays the same in my recommendation. I did make a mistake on page 1. Aiden will be 6 in January, not 5.
All right, other than those changes, you wish for the court to consider your recommendation?
Yes, Your Honor.
All right, thank you. Now, I believe Ms. Moore for the petitioner,
I am.
you may begin with your argument.
Your Honor, I'm going to start with what matters most to my client, and that's the kids. I think that matters most to the court as well. Specifically, we filed a proposed parenting plan, that's document 33, so the court can visualize what Ms. Zilka is requesting regarding legal custody and physical placement. Highlights of those are she is requesting sole legal custody of the kids. She believes in her testimony demonstrates that these parties are unable to effectively communicate to make major decisions in the best interest of their kids. The testimony is also clear that historically, Ms. Zilka has handled all of these decisions. Education, she's been the one doing the homeschooling with the kids. Medical, she's the one making the appointments, transporting to appointments. She's the one doing all of these things and has been for years. Dad was out of state for many years. He was not involved. And he deferred to Ms. Zilka. If her judgment was appropriate then it's appropriate now to continue to make decisions in the best interest of the kids. She testified that she, again, continues to prioritize the kids, even though dad is back in the area. She's still the one transporting them to and from appointments. She testified sometimes it's up to a half a day, just given the logistics of where the kids need to go based on insurance coverage. Specifically with regard to education, I think it's very clear that these parties have reached an impasse and the court will effectively need to award one party sole custody on education. Ms. Zilka's proposal has been that Vivian continues at brick and mortar school with the ability to evaluate that in a few months, as this is her first year. She proposes that the other 3 continue with homeschooling. She's agreed to using Khan Academy. She's agreed to, specifically with Chase, supplement that reading program and agreed to the yearly testing. That certainly will give some additional oversight, both to the court and Mr. Zilka, to be able to monitor how the homeschooling is going. I think it's easy to look at test scores and say, well, this homeschooling was a flop and we need to pivot. And I think that's not really looking at the big picture here. Ms. Zilka testified that the parties, when they discussed this before, had agreed to do more of an interest-based learning program for the kids. They weren't pushing for some formal, strict program. They were looking at interest-based. And so, sure, these kids aren't going to test particularly high. I don't think there's been testimony that they are used to multiple choice testing or probably filling in the bubbles, or the whole setup of it would have been something completely new to them. So I think it's misleading to simply hold up test scores and say that we have to make a change. They cannot be homeschooled. Clearly, this is a failure. I don't think that's accurate. There's also been a lot of testimony specifically with regard to Chase, and the parties have reached an agreement, although it seems Mr. Zilka might be pulling back a bit from that, on Chase, that he can continue to use this program with the agreements that they've built in. And if it would work for their most, my word, not theirs, difficult child, the child with oppositional defiance disorder, the child with these behaviors, if homeschooling works for him, it surely will work for the others as well. And so that's why my client is requesting that. I think even Mr. Zilka's testimony demonstrates that the parties can't effectively manage education, even of Chase, together. And so that's where I think an award of sole custody is appropriate, where one party is going to be making all of the module decisions. Certainly communication, both parents have to have access to all of that. But given Ms. Zilka's background, it makes sense for her to have sole custody, to take the lead on this, and for Mr. Zilka to have access to everything that they're doing and additional yearly test scores. As it relates to physical placement, Ms. Zilka's proposed parenting plan shows that her position is primary placement with her, some every other weekends and Wednesdays for dad. And she believes, based on her testimony, that that's in the best interest of the kids. That's consistent with the past practice. As I've mentioned, she's been the primary parent while Mr. Zilka has been out of state for large portions of their marriage. The children are certainly already adjusted to her home. It's the home that they've been schooling in and living in. They're adjusted to the community. She's been based there consistently during the marriage. It provides for routines for them. We heard testimony from Alexa DeMo that dad really didn't know about the kids, that he thought, Vivian would have this really big external behavior reaction to public school when Vivian is the internalizer. That shows a disconnect between his understanding of how even she processes. Alexa testified that Vivian didn't like doing schoolwork with dad because of how he would compare her to her younger brother. And that dad at that time was really hesitant for public school, which is interesting that now his position is that the kids should be in public school. Mr. Moe testified that Chase had behaviors prior to Mr. Zilka's return, but that he was able to reach baseline. He was working towards regulation. And since Mr. Zilka returned, Chase hasn't been able to get back to baseline. She testified that the kids have fewer rules and boundaries with dad, specifically regarding bedtime and video game use. And that testimony is, she's a neutral party in this case. We've heard testimony from some family members, but she's a neutral party, really only looking out for the best interests of the kids. And so I think her testimony should be given a good deal of weight. I also think the position advanced by Mr. Zilka, where he takes Chase to Northwoods Technical College on Fridays, is serving Mr. Zilka's best interest, but not Chase's best interest. I can appreciate what the guardian ad litem has indicated, which is there may be some benefit to Chase, but this can't be his normal. Given what we've heard, it can't be the expectation that he's going to dad's college and he's just independently educating himself in the corner. That's not in his best interest, especially given his occupational defiance disorder and his emotional dysregulation. This is not setting him up for success. And it makes no sense to uproot his consistency in his education. Ms. Zilka has been the one doing that. She's available on Fridays. She should be continuing to educate him even when Mr. Zilka is at work. Ms. Zilka's proposal regarding exchanges is that the exchanges occur either at activities, so there is no exchanges at the home, but if it is at the home, that it simply be at the end of the driveway, as they've been doing. And as it relates to the guardian ad litem's recommendation, the one thing that stood out to me on page 2 regarding physical placement is she's proposing a 7:30 a.m. exchange time, specifically for Chase when Mr. Zilka is working. And I think the testimony here today is that exchange has been happening at 6:30. And so I think if anything, just the order needs to be consistent on time and what's been happening. Ms. Zilka is requesting child support and certainly guideline support. The court will figure out once it determines placement. That's all she's requesting is guideline child support, taking into consideration both of Mr. Zilka's incomes, as he does have wages and he has disability income. She has proposed an exhibit or a variable expense checklist that's in her proposed parenting plan before the court. We would request that any expense in excess of $100 be talked about in advance. It would be unfair for either parent to simply incur a large expense without the other parent's consent and expect reimbursement. And then I think, as the guardian ad litem pointed out, we need really clear reimbursement language in the final order. So something like, requests should be made within 30 days of incurring the expense and reimbursed within 14 days or something like that. So these parties have really clear parameters on what that's going to look like. Ms. Zilka is requesting uninsured medical expenses be split 50-50 and working to expand private insurance or maybe VA insurance for dental for the kids, given again the long travel for logistics on covered facilities for the kids. The parties have 4 children, and so for taxes, she would just propose that they each claim 2, assuming child support is current through the end of the year. And Ms. Zilka has indicated she's in agreement with continuing to use our family wizard for communication. I don't believe that this is a scenario where they have to have this call feature where it's recorded. Certainly in the event of an emergency, the parties are free to communicate with each other, to pick up the phone and call each other. As the court noted, there are no restraining orders or other provisions. Our family wizard should be the default, except in an emergency. And in an emergency, I would hope either parent would pick up the phone and call the other. Regarding real estate and financial matters, Ms. Zilka's position is before the court, but she is requesting that she be awarded use of the marital home. I believe the value's been stipulated at $230,000. It is desirable for her to continue to remain in the home. And so she is requesting that she has an extended period of time with regard to the mortgage. I know it's typically ordered on a quick turnaround for the refinancing provisions. That would not be appropriate in this case. Ms. Zilka doesn't have employment. She's going to need a period of time with a consistent order, probably consistent child support or what have you, to qualify for refinancing. And it is desirable for the kids to continue to have that stability in their life, the home base that they're accustomed to. As it relates to the Arizona property that has been sold, and I'll talk about the proceeds a little bit as I discuss some debt matters. But Ms. Zilka has provided Kelley Blue Books for the vehicles. She's asking that the court provide or use those numbers that she provided. Her position statement indicates there are several vehicles which she and her father have testified are in really old, rundown condition. They've been at her dad's house for a while. And now suddenly we need to, be assigning values to them and divide it to them. So if anything, a nominal value assigned to those, if anything. I did find it interesting in reviewing Mr. Zilka's exhibits that he does use some of Ms. Zilka's Kelley Blue Book values, and then some he appears to have run his own calculations. So it appears that some of her numbers were reasonable to him and others, maybe he wanted a number more in his favor. But if some are reasonable, then I think the court should use all of her numbers. It makes the most sense. Regarding the workers' compensation claim, it's our position that those funds should be included in the division of this marital estate. The injury occurred during the marriage. All compensation should be considered for property division purposes. And there is a case law on that. It's Krebs versus Krebs. That's Krebs. It's 148 Wisconsin 2nd 51, 1989 case. And that indicates that any compensation for medical expenses, lost earnings during the marriage are considered marital property and subject to division. I think there's been a lot made of this medical set aside. And so 140 needs to be set aside and not touched during this case. And I think that's a red herring before the court. First, Mr. Zilka never even received $140,000 from his settlement. He received approximately 129. It's in the record, but it's significantly less than 140. Also, I believe it's exhibit 107, page 9, that shows that he paid attorney's fees on his full award of $220,000. If it was truly a medical set aside, they wouldn't be pulling attorney's fees from that. And I think page 1 of exhibit 107, where they're suggesting that the 140 was completely kept intact and everything else came out of the balance, I think is misleading, because if you look at page 9, it's very clear that attorney's fees came out of the entirety of the award, the full 220. And so I think it's just misleading altogether. Plus, Mr. Zilka had no problem using $75,000 from this award to make a down payment on property. And so again, I think it's a red herring to say that this 140 needs to be set aside and not touched. I think that's misleading. In any event, on Ms. Zilka's proposed property division, there is page 2, which is a prorated portion in the event that the court only considers using the medical portion. There is an alternative position for Ms. Zilka. I really don't believe that's appropriate, and I believe the case law strongly demonstrates that any awards received during the marriage are subject to division in full, and that is her position. Regarding retirement accounts, the only party here who has retirement accounts is Mr. Zilka, and that makes sense. He was the one working outside of the home while Ms. Zilka stayed home and raised the kids. It would be inequitable, though, not to divide these as part of the marital estate. It would really create a hardship for Ms. Zilka, again, being the stay-at-home parent raising the children. It's our position that all of the retirement accounts need to be included and subject to division. Mr. Zilka did testify there was some stock from a previous employer, which has kind of rolled through in his Charles Schwab now. And so there's certainly some commingling of items here. On personal property, Ms. Zilka, as the court heard, really is not trying to fight about every little thing. I think to the extent that Mr. Zilka is looking for every item in perfect condition in a home with 4 children, probably is unlikely, and Ms. Zilka testified she's not doing anything to the property. Should she find some of these items in the future, she will return them to him, but she simply doesn't know where they are. We can't order somebody to provide something that they can't find. There are disputed items. Ms. Zilka testified to those. Those were on Exhibit 21. And so we are requesting that those be excluded and not awarded to Mr. Zilka. As it relates to this non-marital statement, Exhibit 112, I'm asking that the court disregard any weight that may be given to these items that are alleged now to be non-marital. Ms. Zilka wasn't a party when these agreements were allegedly made. The agreements were made after the divorce was commenced, which doesn't make any sense that those would be legitimate in the first place. But any of those non-marital items listed on Exhibit 112 should be disregarded by the court. There is no testimony other than, I suppose, a bit from Mr. Vincent Zilka on those items, but the people who authored that document didn't even testify to them. Regarding debt division, Your Honor, if Ms. Zilka is awarded the home, certainly she would be awarded the mortgage and responsible for all of her debts. She is requesting maintenance, and I'll talk about that in a moment. Regarding credit card debt, each party should either take their own, and it's our understanding that the joint credit cards are in Mr. Zilka's name, which then he would need to remove Ms. Zilka's name from, or there is funds being held in trust. And so an alternative proposal here would be that the court use some of those funds to pay off these credit cards. And then that's certainly a benefit to both parties to walk out of this with a little less debt. And then the balance would have to be split to equalize property. On student loans, those should be considered a marital debt. They exist at the date of divorce. Those loans benefited the family. Ms. Zilka's education that she received by use of those loans was beneficial to the entire family, as she was the stay-at-home parent and educating the kids. And so they were directly relevant and used during the marriage. Apologize, Your Honor, I'm getting over whatever I'm getting over. In contrast, there's the debt to Mike and Helen Zilka. Excuse me, just one moment. I apologize to have something in my mouth during my closing arguments, Your Honor.
I'm used to it.
I appreciate that. In contrast, as I was saying, the debt to Mike and Helen Zilka was incurred prior to the marriage, and it served no benefit during the marriage. It was used for Mr. Zilka's individual living expenses before the marriage and a vet bill. And so that should properly be excluded, and his individual responsibility. There were no payments made on it during the marriage, and I don't believe any more was taken out based on his testimony. So we are requesting that the court approve Ms. Zilka's proposed property division, which is Exhibit 25. I believe one of the last things, Your Honor, here is Ms. Zilka's maintenance request, and I'll try to cover that briefly, but I believe that's Exhibit 26 in our submissions, and that's based on Mr. Zilka's income and Ms. Zilka's proposed parenting plan, factoring in appropriate guideline child support. That is her request regarding maintenance. And this is a long-term marriage. This is a maintenance case. Ms. Zilka's 41 years old.
They're married 10 years. I wouldn't necessarily say a long-term marriage. I would say midterm.
I would say mid to long-term, Your Honor. I think a 10-year marriage.
I'm the judge. I don't say long-term.
I can appreciate that you've seen certainly significantly longer. As 10 years, though, that's been a fourth of Ms. Zilka's
I've
life.
done many, many divorces. It's classified as a midterm divorce.
Thank you, Your Honor. Ms. Zilka's 41 years old. They've been married for 10 years. She benefited the marriage by staying home with the family and raising the kids. It saved them costs from daycare, childcare during this time. Ms. Zilka has an associate's degree from 2013. She's not updated it. She's not kept up with it. She hasn't taken classes since then. And she desires to continue raising the kids, specifically the agreement at least is for Chase and homeschooling. And so she desires to do that, and providing all of the custodial responsibilities and education for them via homeschool, as she's been doing. Their youngest will be 6, and so that's 12 years to get him through schooling. Realistically, a maintenance award to at least get Chase through schooling would be appropriate. There was testimony from Mr. Harrow as the vocational evaluator, and I submit that the court should give that testimony very little weight. Based on his evaluation, it seems like there was kind of this evolving ball that just kept getting kicked further down. It was first that Ms. Zilka should do in-home daycare, and I think that's unrealistic. It also didn't take into account having Chase in the home with his occupational defiance disorder, with his behaviors, and Mr. Harrow seemed to not contemplate that that was the agreement of the parties, or that that would work with an in-home daycare setting. Certainly would make an in-home daycare less desirable for families if there is a child in the home with such behaviors. That might be an option for Ms. Zilka in 5 years when Chase is done with his high school, but for now that wouldn't be really a viable option. Then it seems on the eve of trial, Mr. Harrow submits a new vocational evaluation, which now opines that she's capable of remote work. And again, that contemplates that she would do so when she has primary placement of the kids, which doesn't entirely make any sense. She can't truly devote herself to her remote work and schooling the children at home. Mr. Harrow, again, wasn't aware that the parties had stipulated, at least for Chase, that he would be homeschooled. And she has no experience in this line of work. Mr. Harrow was unable to say whether the employers that he specifically included in his evaluation would agree to having staff in these roles when they have potentially 3 kids home with them while they're homeschooling. And he didn't really know much about her home setup, whether or not this would even be a viable option. He also then opines that she's capable of earning income via waitressing, which in his evaluation, he imputes income to her for full-time home daycare plus part-time waitressing. And that doesn't make any sense. Nobody here is expecting Mr. Zilka to work more than full-time hours. Ms. Zilka shouldn't be expected to work full-time hours or imputed income at full-time plus part-time hours. That's not the standard for earning capacity. And so again, I would submit that Mr. Harrow's testimony and his evaluation should be given little weight. Ms. Zilka did file her Social Security earning statement. That's document 24. That shows her earning history is nowhere near the amounts that he opined. And it will take her years, which I think Mr. Harrow did agree. It will take her years to build up to her full earning capacity. And so that's where maintenance comes in for a period of time to get her through to a point where she can be self-sufficient. But in considering the factors under 767.56, again, she has this AAS degree from 2013 in early childhood, nothing since then, relatively little employment or work experience since then. Prior to staying home with the kids, she was working part-time in restaurants. She's been out of the job market for 10 plus years now. And it has been her job raising these children while Mr. Zilka was working out of state. She would need to return to school, likely to increase her earning capacity, potentially a bachelor's degree or something that's going to take her some time. And her ability to do that is limited by her custodial responsibilities at home with the kids and education. So it's not something she can just devote full time to while she's taking care of the kids and doing the homeschooling. Mr. Zilka's income had been the sole income that provided for this family. And so the standard of living during the marriage was that his income was sufficient to provide for the residents here, to provide for himself in Arizona, and to provide for the needs of the kids and both parents. And they were able to get by. If we look at the financial disclosure statements from the start of this divorce to present, those demonstrate that they were living within their means. They didn't have a significant amount of debt at the start of this case. And so I believe that that's sustainable. I believe that that can continue. Ms. Zilka will need higher education. She will need training to support herself at that same standard of living. And so maintenance is needed to get her to that point for a period of years at least. Lastly, one of the other factors is the contribution towards the other's earning capacity. And certainly Ms. Zilka has done that by continuing to have the home front with the kids, having the day-to-day care, taking care of them, doing the education while Mr. Zilka applied for jobs in Wisconsin, Florida, Dubai, Alaska. He's looking for jobs all over financially to provide for the family. But by Ms. Zilka staying home, that was her contribution to allow him to increase his earning capacity.
I do have to tell you, you have to speed it on up.
I'm done, Your Honor.
Okay.
That's my request. All of that is supported by our exhibits.
All right, and that is exhibit 26 for maintenance request. Okay, thank you, Ms. Allen.
Thank you, Your Honor. I'm going to start also with respect to the children and the custody placement issues. We are of the position that the parties should have joint legal custody. I don't think there's necessarily any basis just because parties disagree on a way forward. It doesn't mean that then one party should then just automatically get the primary say on these things. I don't think that the standard for sole legal custody to one party or the other has been met. But I would say that if there is a thought that we're going to be looking at awarding sole legal custody for something, say education issues, for example, with all due respect, I think that the exhibits that have been submitted show that this homeschooling that has been occurring through the years has not been successful. I'm just going to leave it at it has not been successful. These children were evaluated by 2 separate facilities, and both times they were evaluated to be very, very far behind. I'm kind of surprised at the that there's not more being submitted with respect to the guardian ad litem's position regarding these educational issues. But this homeschooling has not worked for these children. And I can say, and I think both parties would testify, that initially they liked the homeschooling idea, they want it, but they've also discovered and learned that it's not working. These kids deserve more and they deserve better, and they deserve to have an education where they can read, they can do their math, they can do their science. And what I'm hearing is that we have one parent who is not willing to consider the fact that this isn't working, and she wants to continue to stride on with homeschooling despite the test results that we have seen. And we have another parent who is willing to put what his personal preferences or maybe his personal thoughts were before, and putting before him what he thinks is best for these kids. And in this case, it is a struggle because he doesn't necessarily like public school, but this is the way that he feels is in the children's best interest. He's putting them before himself. He's putting them before what his personal wishes might be. And so if we are actually considering awarding sole legal custody to one parent or the other, I submit that it should be to the parent who is struggling with these issues and is willing to look outside the box, look outside what's been done in the past, and actually move forward. So, Your Honor, if there is a consideration that there's going to be sole legal custody, I submit to you that Mr. Vincent Zilka would be the more appropriate parent to have that sole legal custody decision-making. He has indicated he's willing to communicate. He's tried to communicate through our Family Wizard. He's asked for the phone feature on our Family Wizard because he feels it's more appropriate, and sometimes it's better to actually try to talk to somebody rather than trying to convey everything that you're thinking about in writing. And we have one parent who's willing to try that, who wants to communicate. And we have another parent that's saying, no, I want to communicate via writing only. Not conducive, again, to trying to communicate with each other, to try to really touch and figure out what are the issues, to try to prevent miscommunications, misunderstandings. Sometimes you have to do it verbally. And again, we have Mr. Zilka willing to do that and Ms. Zilka saying no. We have a situation where there are a couple of questions today about, did Mr. Zilka come to the house? He was in the street. So he respected her wishes. He didn't go in the driveway. I'm not really sure what was such a major deal about that, but Nevertheless, he respected her wishes. He didn't go into the driveway and drop something off and left again. So with respect to the legal custody, I think that these parties, if they are actually motivated to do so, can do so. I think that with some of this legal custody, it is true that in the past, Mr. Zilka's been working and Ms. Zilka has been primarily responsible for this stuff. And it is hard to get used to the idea that, yeah, I got to talk with somebody else about this stuff. I need to get his feedback on it, and we need to figure out how we want to proceed forward. So with respect to legal custody, my client is willing and ready to do joint legal custody. But if there is the idea of sole legal custody, again, I propose and I would propound to the court that it's more appropriately with Mr. Zilka. With respect to placement, pursuant to Wisconsin statute section 767.41, in allocating periods of physical placement, the court is required and shall set a schedule that allows the children to have regularly occurring meaningful periods of physical placement with each parent, and that maximizes the amount of time the children may spend with each parent, taking into account geographical separation and accommodations for different households. In this case, we have two parents that live in the same community within I want to say a mile or so of each other. This is a prime and perfect case for the parents to be sharing placement equally. I don't understand this idea that, well, because in the past, they separated their duties one way, that time doesn't progress. And now we have both parents in the same community. We have children who have bonded well with both parents. We have children who have the right to have a good and strong relationship with both of their parents. And again, on this, I say that actions really speak louder than words here. We have one parent who is saying, oh no, I want the kids to have a good relationship with their dad, but it should only be every other weekend and one evening a week, even though we live in the same community. We have another parent who is saying, no, I think it's important for the children to have a good relationship with both parents and maximize the time that the children can spend with both parents. Both parents have something that they can offer these children, and these children have the right to get that feedback and that input from both of their parents. So, Your Honor, we would ask that the placement schedule be maximized with both parents, that Mr. Zilka has submitted a proposed parenting plan, and we're asking that that proposed parenting plan be adopted. He is proposing a week on, week off schedule. With respect to the pushback on bringing Chase with him when he's working, allows Chase to do homework with him, shows Chase other examples of people that are doing their schoolwork, are doing work. I know that when Ms. Zilka testified, she talked about the benefits of homeschooling. Well, we can teach him more practical things, things of that nature. Well, that is exactly what he's going to be getting when he's spending time with dad. Also, I can say from my personal experience, whether it's appropriate or not, but sometimes that time when you're driving the kids to school in the morning, or you're picking them up and you're driving them home, those are huge times. That's where you really get to talk to the kids, really find out what their day was like, what's going on with them. It is perfect conversation time between dad and Chase when they're going there. And so we really do feel that an equal placement schedule would be appropriate. What my client is proposing is consistent with this idea of maximizing the children's time with both parents. Another factor the court needs to take a look at is that one parent going to unreasonably interfere with the parent's relationship with the kids? And again, I would submit that a proposal that Mr. Vincent Zilka have only every other weekend with his children speaks volumes with respect to what mom thinks about dad's relationship with the children and whether she's really willing to promote that and really willing to facilitate that relationship. With respect to the holidays, again, Mr. Zilka submitted to the court that he realizes that the holidays are really important to Ms. Zilka. So he's willing to say, hey, yes, for most of these holidays, she can have the actual day as long as I have time around that. Again, doesn't speak to me as someone who's being rigid and unreasonable, unwilling to work with her in order to get things resolved, in order to move things forward for the kids. we are asking that with respect to the children, that the three younger ones go to a regular brick and mortar school. I think we've touched on that. I've touched on that a little bit in just my discussion about the legal custody issue. But I think that these kids are getting the short end of the straw here with respect to their education. And something else needs to be tried. We agree with the guardian ad litem that the three younger children should attend public school. With respect to Chase, they have agreed to try this method, but they've also agreed they're going to evaluate on an annual basis. So it's possible that if this isn't working, maybe it's going to have to be reviewed again, because really we need to be putting Chase in the forefront here, and he needs this educational assistance. So with respect to those matters, running close on time. So that is what we're requesting. His request is also in his proposed parenting plan that we would ask the court to review and adopt. We believe that it is something that maximizes the children's time with both parents, and we believe it is in their best interest. Going to the property division, we have submitted Mr. Zilka's financial information with respect to the personal injury claims that have been submitted. I disagree with Ms. Moore's interpretation of the case law as it relates to personal injury recovery. I think the case law is very clear that personal injury recoveries are not subject to a presumption of equal division, that they are actually presumed to be belong to the person that was actually injured. I'll start first with the Krebs case that was referred to by Attorney Moore. And that case does refer to the Richardson case, which was the first case that dealt with personal injury claims in a divorce.
I'm very aware of the Richardson case, not so aware of the Krebs case. So I do need to read the Krebs case, but I'm very aware of the Richardson case.
Okay, so the Krebs case is once again relies strongly on the Richardson case, and Attorney Moore gave you that cite. And then the other case that's very relevant to this issue is, I assume the court's going to be reviewing all of these cases?
Yes.
So that case is the Weberg, W-E-B-E-R-G v. Weberg, 158 Wisconsin 2nd, 540.
I am aware of that case as well.
Okay.
But I will review all
Right.
three.
And it's clear with these cases that personal injury payments, even if they're already made, are not presumed to be divided equally. And there is a difference between recovery for lost wages during the marriage, which would be marital, and a difference between future medical expenses that might be covered, and a difference between what's recovered for personal injury, the pain, suffering, disability. So our position is all of those cases make it very clear that Mr. Zilka's personal injury recovery should not be presumed to be divided equally and should in fact be awarded to him. Now, it is true that he had to borrow against his Medicare so that he could find a place to live that's close, so that he could put himself in a position to come to court today and have a request for equal placement make sense and be reasonable. So he did borrow that money, but it is something that he's going to have to come up with later in the event he does need medical care that's not going to be covered because it's related to the work comp injury. So I believe that the court cases and the information that was submitted to the court firmly set forth the basis for that income. Attorney Moore is correct that the attorney's fees were paid from the indemnity portion of the recovery, because they can't take it from the Medicare portion because that's supposed to be saved for future reference. And that information is in that exhibit that we stipulated to allowing in. So that information regarding that claim is submitted. We believe that personal injury line of processing also includes the hearing disability claim that Mr. Zilka has as well. And so we would ask that both of those, the work comp settlement and the disability from the hearing loss, the 3M settlement, both be awarded to him without division. With respect to the marital home that Ms. Zilka is asking be assigned to her, we agree that it is valued at $230,000, but we would ask that she be required to get that debt refinanced within 90 days. My client also has financial obligations and things that he needs to meet and be able to do, and that is a debt that is hanging over his head as well. So we're asking that she be required to do that within at least the next 90 days. With respect to the proceeds from the Wisconsin or from the Arizona home, that is available for the court to utilize in dividing the assets. We agree that the debts that are identified on my clients, the credit card debts, are marital debts to be divided. With respect to Ms. Zilka's student loan debt that is premarital, we believe and we would ask that that be assigned to her without division with Mr. Zilka. I haven't seen how she really utilized that education during the marriage. I don't see how her student loans actually benefited the marriage. So we would ask that that be something that is assigned to her without division. With respect to the other asset values, those were submitted. My client submitted Kelly Blue Book statements. And we would ask that the court utilize those for purposes of valuing the vehicles. And that the court utilize the property division net worth statement that was submitted to the court as exhibit number,
I'll find it.
okay, 118. With respect to,
Once the party's divorced, you gotta get going.
and again,
Otherwise,
we're
we're
at the,
having another date in February.
and again, we're at the position where I'm left with 15 minutes. And so, Your Honor, I'll just,
20
I understand,
actually.
what,
You
pardon?
had 20, actually.
20 minutes, all right, thank you. So with respect to the maintenance issue, I would ask that the court find that Ms. Zilka has an earning capacity of $44,000 or at a minimum amount, $30,000. That, along with what the court determines the guideline child support to be, will be more than sufficient to meet her needs as she's identified in her financial disclosure statement. The suggestion that she doesn't have to work and doesn't have to get a job, can just sit back and have Mr. Zilka support her. I don't think it's supported by the law. I think that she could be viewed as shirking. The court, you may recall at one of the prior hearings, instructed her to look for work and to get a job. And her testimony was she did not get a job. And her testimony was also she didn't even look for a job. So despite the fact that the court told her to get a job, she just didn't do it. And it's not, and when we're talking about maintenance, it's support and it's fairness. And it is not at all fair in this scenario for Ms. Zilka to continue to stay at home, to not work, to not contribute to her financial support at all, while Mr. Zilka not only is living on his disability, but he actually, even though he's 100% disabled, went out and got another job. So he certainly could just sit back and do what she's doing and not get a job, not work. And perhaps that's maybe the fair way of determining what's an appropriate calculation for purposes of a maintenance claim. But again, when she's working, and with the child support, she will have enough to meet her needs as she's set forth in her financial disclosure statement. With respect to the support piece, again, she can work. I've not had a case where someone just believes that they should just be able to stay home and not support themselves, not contribute to the financial well-being of themselves and their kids.
I've had plenty of cases where that's argued.
Okay.
Similar cases to this, quite
okay.
honestly.
All right. But also the suggestion that she should be able to not work because she wants to stay home and take care to homeschool the kids. again, that shouldn't be a reason and a basis in this case to allow that to occur. Once the children are in school, which is what we would submit should occur, she's got the time and the ability to get a job and to help support herself and to help meet her financial needs. Lots of parents work full-time and take care of their kids and do the things that they need to do. So we're asking that her request for maintenance be denied because she's got the ability to work. She has the ability to meet her needs if she would have just gone out and done it. And so from that perspective, that's what we would request occur. With respect to the random personal property items, my client testified about his reasoning for why he wants some of those things. I know the court's got it in its record, so I would just defer to my client's testimony with respect to those items of personal property. I guess the one that sticks strongly in my mind is the wood cutter, chopper. Splitter, the wood splitter. And my client testified that with respect to his current home, he actually has a wood burning stove, right? And so that's something he actually could use versus Ms. Zilka testifying that the kids use it sometimes for Cub Scouts. I'm sure if the kids needed it,
Adults can buy their own.
right, or I'm sure he'd let them borrow it. So we would ask that that be awarded to Mr. Zilka. And I'm sure I'm always doing these things. I wish I was more better spoken, but I think that we've.
Miss Allen, you have said it, you did say it correctly. You have been put in crunch time both times, unfortunately, but fortunately for both of you, I listen very carefully. I take very detailed notes, and I have very detailed exhibits to go by. I go through my notes, I go through my exhibits very thoroughly. I will again read those cases that have been cited. I am very thorough in my job, very thorough. Not sure about other judges, can't say. I'm very thorough. Because quite honestly, your life, your children's lives depend upon it. And that's why I do my decisions very quickly. I have 90 days to do them. I don't take 90 days. The most I've taken in a family case may be probably 3 weeks, perhaps 3.5 weeks to reach a decision. And especially in a case as, I want to say, as complex and having a lot of issues as this case, I can't see it'll take me longer than that either. The more difficult time in getting a time is going to be fitting it into my calendar and yours for the oral decision. Because I will not get my written decision out before I give my oral decision, because again, this is a divorce, and a divorce does not only impact both parents, it impacts those beautiful 4 little children. So before we begin and I divorce you, let's get a date and time for the final hearing. I have pretty much a lot of availability the week of January 13th through the 17th because I have had trials, etc., removed. Anything work for the parties? I prefer in person because then I can look at you directly and you can look at me. Ms. Landgraf, you can appear by video, save some time and money.
Thank you.
And that is, you don't even necessarily need to appear unless you just want to hear.
And I'm sorry, Your Honor, what date?
January 13th through the 17th, I'm pretty much open a lot of the time that week, except for the 16th, I guess. Monday, Tuesday, Wednesday, or Friday.
I can make any of those work.
I'm available all day on Tuesday. I would have no barriers to the court.
I would prefer Tuesday afternoon.
1 o'clock?
Perfect.
Yes.
1 o'clock, Tuesday, January 14th. 1 o'clock, Tuesday, January 14th. I will set it for probably a half an hour just to make sure that we have enough time.
Your Honor, that is Chase's birthday. I don't know. That's the oldest son.
Well, is he
It won't
gonna be here?
It won't be the effective date of the divorce, but just so everybody knows.
But, and Your Honor, is there any way we could do it sooner than that? Is my client needs to do his financing,
Oh,
to get it
That is
finished on the
it. I can go
31st.
later. Can't go sooner. That's my soonest. I can go January 28th at 1.
Nope, 14th we'll have to do.
That's it. I can go later, not sooner. So January 14th at 1 o'clock. The court finds, based upon the testimony of the parties here today, the exhibits received, and that all necessary residential and jurisdictional requirements have been met. The applicable waiting period has lapsed, and this matter is properly before the court here today for a contested divorce hearing. The court further finds that the marriage of Vincent and Geneva Zilka is irretrievably broken. There is no reasonable chance of reconciliation. The court is going to stay on legal custody and placement of the children. The court is going to stay on maintenance. The court is going to stay on property division and debt division of the parties. The only thing that the court is going to do here today is divorce the parties here at 12:05 p.m. You are officially divorced. You may no longer, you are no longer married. You may not marry anyone else in any jurisdiction across the world for 6 months. If you do, it is a void marriage. I am not sure if you wish to wait on drafting of findings of fact, conclusion of law until I do my written decision. But Ms. Moore, that is going to be your responsibility to draft, but you can wait to do so until you receive my written decision. And I will give you ample time to do so after that January 14th date. But as of this date and time, you are now divorced. Right? Anything further?
I assume, Your Honor, that with respect to the financial orders that are in the temporary order, those are still
That
in
still
play.
continues
Yeah.
until the court makes its final decision as of January 14th.